Yes, Mr. Gaur.
I think extra month.
Today,
No, tomorrow it may be listed tomorrow.
motion, motion. Is it for motion? Okay.
May please, your lordship. Lordship, I am praying for listing of two matters on motion, lordship, on tomorrow, lordship. Obliged.
Tomorrow or day after tomorrow.
Motion.
Yes.
Ma'am, motion for tomorrow, ma'am. We are filing today, ma'am.
Ma'am, please. The case of the petitioner is a non-renewal of his license, my lord. Lordship will be as per the first report at page 68, my lord. This is the one of the police report, my lord, page 68. Basing on this, my lord, I was issued a gun license, my lord. That is at page 70. And it is valid up to, my lord, 11/6/25. I approached to the authority, my lord, by filing application. Then again, a report was sent by the concerned police to the deputy commissioner.
Who are you?
My lord, I am a businessman, my lord, ex-candidate of Legislative Assembly, my lord, and I have a risk hat also, my lord, for which, despite of having, my lord, security, my lord, my head was broken, doubt and all that. I have annexed those cases also, my lord. And then lordship will see page 75.
You want to go to the Legislative Assembly,
Yes, my lord, because.
and for that you need a gun.
My lord, gun already been given. I had given initially, my lord,
Huh?
security.
Are you not required to surrender your license before the elections?
My lord,
Surrender your gun before elections.
yes.
So these elections you are going to fight. So there is no urgency out there.
After election, it was given to me.
So after let these elections be over.
But by this time, I'll be eliminated, my lord.
Huh?
By this time, I'll be eliminated.
When was the last renewal done?
Lordship will see. This is
Last
the first
renewal done when?
First renewal,
First renewal.
my lord.
Oh,
I was given at page 70, my lord.
where is your application?
Application I have annexed, my lord. This is page 71, my lord. And 72 is the online.
You have been given a PSO.
Earlier, my lord.
Now you don't have a PSO also.
That has been withdrawn. I
Sorry.
filed the writ petition also, my lord. Honorable court directed to consider, but my case was not considered.
Now has it been rejected?
No, my lord, they are asking for same report, my lord. Lordship will see page 75 and impugned order, my lord. Subsequent report was submitted, my lord. It took over. Five. 75 police authority, my lord, submitted report to the district magistrate at page 75 in respect of my license, renewal of my license.
All the cases filed by you, what has happened?
Charge sheet. Charge sheet. And I have the next one photograph also, my lord. I was almost that run, my lord. I had been hospitalized for several days.
Okay, okay. Issue notice making it returnable on after elections.
And a short day.
Okay.
Your lordship grant me,
On
give him, my lord.
what interim that you need the license for the time being to run?
Not that. I may be permitted to use, my lord.
My goodness.
Our lordship issue also interim notice also, my lordship.
issue notice making it returnable on 19th of January 2026. Mr. B. Bukiel appears, accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the writ petition be furnished upon him by tomorrow. Date to date. The petitioner herein was issued an arms license bearing license number, to page 71 of eta lomba number eta ase. Full stop. The said license expired on 11/6/2025. Prior to that, the petitioner submitted an application on 22/5/2025. However, the respondent authorities have not renewed the same in spite of a recommendation being given by the Senior Superintendent of Police on 10/9/2025. It is under such circumstances the petitioner has approached this court. The respondents are directed to bring on record their stand as to why the petitioner's license have not been renewed. By filing their affidavit on the next date. What is this? Huh?
Down payment of admitted amount, my lord. My lord, from the same, thing that some person has already been given the money. Page 41, 42.
Assam Seeds Corporation.
Notice is.
I will serve copy it upon the Mr. Samaria. No. Then how can we do it?
Copy has been served, my lord.
Huh?
Copy has been served.
Upon Assam Seeds Corporation. Have you served or not? Why is he not appearing? Has his name been shown in the cause list? Nila file to saw. Serve position in there.
City Corporation not so much.
They have a standing council.
Lordship.
Yes. Not served.
Agriculture department.
Agriculture is different. Then
I can serve that.
this matter again on 19/12/2025. In the meantime, the petitioner is directed to effect service upon the Standing Council of the Seeds, Assam Seeds Corporation Limited. Seeds Corporation, what is that? Assam Seeds Corporation Limited. Should the name of Mr. S. Samaria be reflected in the cause list? What is this?
The pursuant to an order passed by the Chief Secretary on the direction of the Honorable Supreme Court, page 30. The Chief Secretary took a decision to accommodate the petitioners by allotting a plot of land. After this order, nothing happened. We instituted a petition. In fact, by an order passed by your lordship on the first, after 2 years,
They say that they have given a plot of land.
given, there was a condition
Hmm.
and there was an undertaking given before your lordship that as the condition was 3 years, within 3 years, they will have to use the land for the purpose it is allotted. And there was an undertaking given by the government council that they will develop the land and hand over to the petitioner.
Hmm.
But despite that, Malab, till now, nothing has happened. Your lordship will kindly see the last order, Malab, at page 101. The relevant, Malab, paragraph 8 onwards, 104. Paragraph 8 onward.
Yes. Have you given it to a copy to the GMC?
Yes, she is appearing for this.
You are appearing. Why you are not doing anything?
Actually, I have to obtain my instructions.
What? Ask your senior. Who is it?
Lordship P. Nayak.
Huh?
Lordship P. Nayak will.
Mr. Whoever it is, Mr. S. Bora, he was appearing on the earlier occasion.
Today, Mr. Nayak will appear.
And what is the DC doing? You? Why you are not taking any action? You have handed it over on 10/30/10/2024. The name has been changed in your name now, but they are to develop.
They are to develop.
They have not developed.
No, because the last portion of page 30, the order my lord of the chief secretary. Check will find it, page 31, last paragraph. That was the decision by the government. After careful consideration of all relevant records supplied by the deputy commissioner and circle officer pertaining to so and so, it is ordered that all the 240 members said plot of land and to be handed over to the GMC, report received from the. deputy
GDD shall provide a minimum
Yes.
required time necessary for development of the layer with shaded market. They have not done that.
Nothing, my lord.
Who is paying for the
Even
GDD?
that-
You. You're standing counsel.
Lordship, no, I'm appearing
Yeah.
on behalf of Mr.
None
Pina.
appears.
Lordship, he is on legs in court one. Lordship may take up the matter after some time.
You do one thing. Let me pass an order asking to be there. Wait there out there and then directly file an appeal there.
Lordship, after some time.
Asking the chief justice out there, you can get an order that this court should, the order should be vacated. Don't need even the petition.
Lordship,
Better.
after some time. My senior will be here, Lordship.
This can't be done. No. Issue notice making it returnable on 28/1/2026. Mr. B. Bokiel accepts notice on behalf of the respondent number 1 and respondent number 6. Mr. A. Solia accepts notice on behalf of the respondent number 2. Mr. S. Dutta accepts notice on behalf of respondent number 4. Ms. So-and-so accepts notice on behalf of the respondent number 3 and 5. As all the respondents are duly represented, extra copies of the writ petition be furnished upon them during the course of the day. The petitioner herein, which is a society registered under the provisions of the Societies Registration Act 1860, are aggrieved by the inaction on the part of the respondent authorities, more particularly the respondent number 3 and 5, in taking effective steps for development of the land, which was the decision of the government on 11/5/2018, and due assurances were also given to this court at the time of disposal of WPC number 1173, isn't it?
Yes,
/2019,
order it is.
which was recorded on which was duly recorded in the order dated 18/12/2023. Full stop. The respondents, therefore, are directed to apprise this court by filing their affidavits on or before 22nd of January 2026 as to why effective steps for development of the shades, of the market shades, have not been carried out till date by the respondent, by the respondent authorities, more particularly the respondent number 3 and 5. Full stop. List accordingly. What is this? Such a long name?
See what has happened.
Northeast Heavy Goods Truck
This, main-
Area
what
Truck
has happened-
Owners and Drivers Welfare Association.
This is what has happened. Your
What do
lordship,
they
the
do?
Truck of the petitioner has been illegally detained. In the-
Huh?
It is, the truck of the petitioner is illegally detained in, it's a coal laden truck coming from Meghalaya to Bihar. Yes. Earlier also, your lordship has taken up one matter. The same thing has happened. That same police station has detained one truck. Lordship has by order dated at page 40, order at page 40 has stated that issued notice. After receiving your notice, your lordship has that truck was released. So they withdrew the case. Again, the same thing is being done again by the same police station at Srirampur, your lordship. And this, again, this truck was again being detained. This is a coal laden truck. All the documents are there, your lordship. I've given all the documents and everything was there illegally without any notice, without following any due procedure of law. They have detained this. Lordship's order at page 40, lordship will remember. There was an order, the same thing, same, your lordship, police station has again detained this truck of this petition.
So you have made a cyclo-style petition here again.
That was easier,
So I,
but only the.
so
only-
should I incorporate a similar order like 22/8/2025?
Almost similar, except the respondents has been changed a little bit. And the names of the parties.
You'd have
and the-
done that
and the
also.
Truck number, party's name are a little bit different.
Yeah, there is no truck number or truck
Yes.
numbers are different.
They've given the truck number UP.
Who is detaining it?
The police station at your lordship. Sima.
Respond number 5.
Simal Topo Police PO. That is at Gusaigaon Police under Gusaigaon.
What is this in charge?
This is under Gusaigaon, respondent
No,
5 and 6.
what is this respond number 6 in charge means what? Is there any post, any position?
The charge,
What is this? They can be, is there any designation like in charge?
there
Huh?
cannot. be-
No, madam.
Then
It should
what
be,
type
I
of
think,
petition is
either
this?
C or anything,
OC you have already made
No,
number
no.
5.
5.
Then who is this? 6?
It should have been, I think. I have not seen it.
Huh? Or have you started developing a new position? Whom should I
In
need?
charge of that particular police.
What in charge of this?
Then
building?
it
This is
should
not
be an
done.
SI. It should be an SI.
We strike off number 6. 6 cannot happen.
Lord,
And why you are making the commissioner and secretary Union Ministry of Coal a
because
party?
matter is relates to coal trucks.
So
They have
coal,
issued-
coal tomorrow anything happens out
They
there,
have-
you make the ministry a coal,
they have
party
issued
a
all the
coal.
license and everything.
Additional
They should be
Chief
found
Secretary,
in-
Government of Assam Mines and Minerals Act.
because
This
your-
is an action taken by some
police,
police
not us.
officer
I understand you.
doing it.
The only thing is that.
So we
the
strike
essence
out
of-
the names of respond number 6 to 8. No business out there.
Lordship can do that. You can do that because though it licensee.
Yes, madam.
Yes, Lordship can do that. Because basically, these are all licensees who has given the.
You are carrying a particular truck laden with coal from Meghalaya to Bihar. Now he has stopped you. In spite of giving all the documents also, he is not allowing you to go. That's it.
That's
This is being done by whom?
by this particular police station
By the officer in charge.
officer in charge of that, Simal or something like that.
So you say that he is doing again.
Under Gosaigaon.
So the officer in charge have done it.
No, officer in charge have not done it, the police have done it, you know, so they are keeping the truck in the police station.
So there is somebody else who is exercising certain powers beyond beyond the authority. So why is he not made a party?
In person,
Huh? He should have been made a party if you are saying so. Otherwise, it is the officer in charge.
because your lordship, the police station has kept it.
So we
Oh,
only
government-
say that the officer in
If
charge has
officer in
done.
charge, the authority concerned, he should not have allowed it to happen, you know.
Yes, what is this? Why you are keeping it?
I have to take instruction, my lord. There is no seizure, etc. also is there.
That is
my
what.
lord. Yes.
That is the problem. You keep hold the vehicle. What is your power to hold the vehicle? The police.
We don't
Power,
need seizure.
you can very well hold it.
Yes.
For how long? You can't hold it for a material point of time.
If there is some irregularities, then that can be.
Very well.
specified.
We get our instructions on
Yes.
19th
Yes.
before the vacations. Chalo. Issue notice making it returnable on, we strike out the 4, all the others 6 to 9. Issue notice making it returnable on 19/12/2025. Mr. M. Sethi accepts notice on behalf of the respondent numbers 1 to 5. Extra copies of the writ petition be furnished to him during the course of the day. As regards the respondent number 6 to 9, this court is of the opinion that the presence of the said respondents are not essential for is not necessary for an effective adjudication of the instant proceedings. Accordingly, the names of the respondent number 6 to 9 are struck off. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties by tomorrow before the registry of this court, and the registry on the basis thereof shall make necessary correction in the cause title as well as update the same in the CIS. The grievance of the petitioner herein is that members of the petitioner association carry on the business of transportation of coal. In this regard, a coal laden truck bearing registration number UP 53 ET 1683 87
1687.
was destined from Meghalaya to Bihar. However, the respondent number 5 have withheld the vehicle, have not permitted the vehicle to proceed. Since
4th of December.
4th of December 2025. Full stop. It is the contention of the petitioner that all the documents necessary have been provided to the respondent number 5, to the officials of the Gosaigaon police station. However, the respondent authorities, the said respondent, that the officials of the Gosaigaon police station have not released the vehicle. Full stop. The learned counsel appearing on behalf of the petitioner further submitted that not only the officials of the Gosaigaon police station have not released the vehicle, but even have not seized the vehicle or taken any steps as is required under the authority of law if a vehicle is required to be withheld. It is under such circumstances the petitioner had therefore approached this court by filing the instant petition. Mr. M. Setia, the counsel appearing on behalf of the respondent numbers 1 to 5 shall obtain instruction as to what steps have been taken as to why the vehicle of the petitioner has been withheld, and as to whether the vehicle in question or the goods in question, goods laden therein, have been seized. Full stop. By issuance of proper documents. Full stop. List according. File the. Yes, Mr. Dekar.
Lordship, you also already fixed the matter on 2nd of February, that cancellation of fast track license.
Oh, same order.
Yes.
We put Miss Yuda's name
Yes, yes.
so that later on we can catch hold of one of.
6 also similar.
Huh?
Do you think item 6 also similar? Obliged.
8 to silo, cancellation.
This matter can be taken up after some time. He will.
Who? Let us see what is he filing. What is your case?
I have a contract with the railway department for construction of minor bridge and art filling works from Moinakpuri to Jogi Gopal. In the tender process, there is 29/12/2011, phase 30. And after that, I have completed 70% of the work. And because of the delay of.
Why are there is an arbitral award?
arbitration award because they have started to encase my bank guarantee and other things. I have to approach this honorable court for appointment of arbitrator. And arbitrator has already passed an award stating that what is my entitlement after deduction of forest royalty also. So they have calculated forest royalty also. Thereafter also they are demanding rupees 10 crores and odd from us.
Huh?
10 crores and odd as a forest royalty. And they one declarance, thereafter they will make the payment. Otherwise not. I have no.
But why you are asking that first one, the first relief? Rejoinder of causes of action. We are not going to pass that order. We strike off this prayer. As regards the other two, to pay the forest royalty, if any, to the forest department in case of. Huh? So your entire case is against the forest department.
Because railway is demanding.
No, Mr. Counsel, kindly see. First is as regards, first relief pertains to as regards, you want an execution of the arbitral award in a writ petition, which you cannot. You have to go under 36. Second, you are saying to direct the railway authorities to pay the forest royalty to the forest department.
No, that cannot be done.
That is, you are asking. Once you are asking this, then how do you ask the third one? Your writ petition is wrong. You need to withdraw and file a fresh one. You see, first we can't give. Second, if it remains, third cannot be there. And third, second, if it goes, third also goes. You are asking that he should pay the forest royalty to him. And you say him not to recover it from you. What is this means? Is it understandable anywhere? Very difficult. Is it, Mr. Gogoi? You are the most ardent supporter of forest royalty. Tell us.
When one
Is it possible?
regarding,
Not possible.
regarding,
You have to come up with this that they cannot claim forest royalty. That is your case. This is not how you do it.
when Lordship's judgment was in respect of forest royalty, Lordship's judgment was appealed by the division bench Lordship.
Which one?
NC Das Lordship.
Which one? I've given so many.
Railways NC Das that three matters
Oh.
forest royalty Lordship has decided in the single bench. It was appealed by the honorable division bench.
So take that help.
Lordship.
You need to withdraw.
Even Lordship,
Come up with a fresh one, liberty given, because otherwise 2 and 3 is contradictory. And 1 can't be given.
one Lordship he have to approach before the section 34 core executing court.
He will do it. He knows 30. He will go as per 36.
Lordship.
36.
36, otherwise the.
Now he is not aggrieved by the award. He wants the award.
The power which was given under section 34 is the proper court to execute a.
Yes, yes. He will go there. He will go.
Section 36.
Mr. S.K. Goswami, the learned counsel, heard Mr. S.K. Goswami, the learned counsel appearing on behalf of the petitioner. Mr. K. Gogoi appears on behalf of the railway administration, NF Railway. And Mr. R.R. Gogoi appears on behalf of the Forest Department of the Government of Assam. Mr. S.K. Goswami, the learned counsel, submits that the petitioner, that there is some formal defects in the instant writ petition, so he may be permitted to withdraw the instant writ petition with the liberty to refile by removing those formal defects. Taking into account the above, the writ petition therefore stands closed on withdrawal. Liberty, however, is given to the petitioner to refile by removing those formal defects. Yes, what is your case? The voter.
The voter earlier approved the honorable court lordship, the order that lordship the page 53 lordship.
Huh?
53 lordship.
Page 53. What happened? She is having all the relevant documents and after petitioner shall submit a certified copy of Iman and impart status of Iman and survey required shall refer the petitioner on her reports to the council. Okay, then what happened?
Lordship, then next is Lordship, the Superintendent Police, the report sent to the election officer, Lordship.
Then
The no Iman has
reference
been
I have the honor
reloaded.
to enclose herewith a judgment and order received from the superintendent of police for your decision. With regard to your request to do one with the of the directive of the ordinance, please submit compliance report. Then
Next page, Lordship.
the letter also clear for the election.
Sent to the letter, Lordship, the.
Then
election-
you are still D
Lordship.
and they have not referred.
No, Lordship.
Why? Who is appearing for SP border? Isn't it your responsibility to do that? Why haven't you referred till now? You are a standing counsel or just standing as a proxy? Proxy. Get hold of your standing counsel. We'll ask him. No proxy business. You wait.
Lordship.
What is this, Mr. Sutia?
Petitioner's prayer is that
What type of
my lord, there is nothing about the no order has been annexed.
petition has
to
been
the-
filed in the premises? Your lordship would be pleased to admit this petition, call for a rule issued so and so, so and so, so and so, as to why the application for the present relief and after.
My lord,
What is the relief?
my lord.
Oh, relief is there, page 7. Restore the boulder supply permission to the petitioner unit QR so and so, so and so, so and so, so and so. Direct State Bank of India not to take any course of action during the pendency. What is this?
My lord. Petitioner obtained loan from the bank. Bank issued notice that he could not get the my lord boulder from the Karbi Anglong, my lord. As there is a mining operation has been closed, so he has filed a writ petition. First synopsis, first paragraph, direct the action of the respondent number 3 divisional forest officer abruptly cancelling the permission for supply of stone boulders.
Where is the cancellation order?
No order has been annexed.
Huh?
No order has been annexed.
Oh, none appears on behalf of the petitioner on call. Mr. J. Sutia appears on behalf of the Karbi Anglong Autonomous Council. To stop. Taking into account for end of justice, the matter stands adjourned to be listed again on 19/12/2025, comma. It is observed that if the petitioner is not represented on the said next date, it shall be presumed that the petitioner have lost interest in the instant proceedings.
Really lot. And the 5 items are in respect of somewhat similar. Regarding pension from contract, may I include?
Washing and NIT, 112, why?
May I include your worship to take up item 23 first, my lord.
Oh, 23 condition.
Almost, my lord. It is the second muscle to confusion.
Yes.
These are all contracts under the irrigation department of the BTC for, my lord, the construction of, the canals, my lord.
Construction of
Canals, my lord.
canals, okay.
And, the work has been divided, in different groups, my lord. Now, so far as this petition is concerned, my lord, there was a competitive bid and, my lord, the contract was awarded on 15/7/2025. At 17, my lord.
This is a letter of
This is our
acceptance.
expense,
my lord, accept.
As per recommendation of so and so, you are hereby requested to furnish performance. So it's a conditional. Then,
Then, my lord, page 18 is the notice to.
so you submitted that 2% offered value.
My lord,
You have submitted.
yes.
Have they accepted?
Yes.
Then,
Then, my lord, this notice to proceed with the work was issued. That is at page 18.
okay, page 18. Yes.
Page
Then,
18, my lord, your lordship would kindly to take note, my lord, the period is 12 months. Period of
Okay.
Completion of the work is, my lord, the 12 months.
Hmm.
Then, my lord, site was also handed over. And eventually what happened, my lord, because of the flood, initially because of the flood, my lord, I have annexed the photographs, the work could not be started. And thereafter, my lord, it was crop season also. Then, my lord, it could not be started. Then, my lord, the British election failed, my lord, the new regime came. And there was a decision to cancel, my lord, all the contracts where, my lord, this work has not started. So that was the decision taken, my lord.
so you are going to complete it within the 6 months?
In next 6 months, I can, my lord, within this period, my lord, I can complete, my lord.
And if you don't,
Then,
is
my
it
lord,
there an undertaking that you are going to complete it within 6 months?
my lord, we will give an undertaking to that effect, my lord. I will repeat that in.
Yes, what is the reason of cancellation?
Region of cancel, if your lordship kindly comes to page 37, my lord, that is a letter of the BTC chief. Page
No, so
30
there's some minutes
yes, my
at
lord.
page 33.
Yes, my lord, there is a, my lord, minus is at page 33, my lord. Then the relevant clause is 4.1 at page 35. 4.14 at page 35, your lordship will find, my lord. The issue discussed and decided to cancel.
4.1.
4.14.
One,
Is 35.
1.4, where is that?
Page 35, my lord.
Ah, 4. The EC discussed and decided to cancel all administrative delay when no work order against the scheme was issued and where work order has been issued but work had not started at the site. Okay. Then
Then, my lord, finally.
they've gone for a fresh tender.
My lord, the finally, that termination order was issued, my lord, page 41.
Then,
Then, my lord, the fresh NIT has been issued, my lord.
so you have apply.
No, my lord.
Why?
There is still time, my lord, for that.
Apply. You'll get it. What is there to fight? You have not started any work.
My lord, I have given all the security money and other.
Security will be adjusted, will be returned. Have you not returned with the cancellation?
My lord, after cancellation, steps has been taken for refund of the aforesaid amount.
My lord, if your lordship permits, my lord, then we can complete the work within that period, my lord.
No, how can I do so? They have cancelled it. Because why should I stay this? This work is this is the winter season where the work has started. You yourself say that monsoon was there, then crop season was there, floods and all these things. So you can't do the work in the month of July onwards. You couldn't do the work. You didn't start the work. So what is-
My lord, if your lordship kindly sees, there is a report, my lord, physical verification report at page 38, my lord, by the executive engineer. He has recorded the region, my lord, page 38.
Yes.
This is the report, my lord. A physical progress report by the executive engineer. To the-
We are concerned with which work?
Then you, page 39, your lordship will find, serial number 5.
Field condition, crop season. Eh? Rightly so. Okay.
Then, my lord, the next page, your lordship will also see, my lord.
Division bench, division bench,
My lord.
division bench. Division bench will help you out. Let me dismiss it. You see, if I issue a notice today, I'm not going to stay it. You go there, he will file it. In the meantime, tender will be done. Then tomorrow again, you are going to have a problem out there. You can't do. In the meantime, they will go ahead with the work. And then later on, it will be infructuous because of the delay of the court. So
Unless your lordship, my lord, stays the NIT, my lord.
I'm not going to stay the NIT because it makes no sense staying because this is the main season to work. You participate in the tender process. They will return you. Because I don't stay. on a tender process normally, unless it is so grave.
Here is the case, my lord, after the regime is changed, my
No,
lord.
I would have understood you have done some work and there is some problem out there which appearance out there that they have not taken into consideration that. If that was the thing, I would have definitely interfered with it as regards the cancellation I'll state. But this can't help.
Of the materials, my lord, for the work.
You don't have a right. You have been issued a notice to proceed with the work, but you have not done anything.
Because of the ground situation. Because of the ground situation, we could not start, my lord, the report also supports that.
But you knew about that. When you submitted your tender prior to 25/7/2025, you were much aware that this is the situation.
That flood.
Flood, crop season, all these things are there. So you cannot say that I have not touched or even I have not done anything out there. If you have done something, it's okay. 5% also it would have been some. I don't know case. So better I dismiss your case so that you can approach the division bench. The division bench may help you out.
My lord, my submission is that that flood is that factor is one of the force majeure. my lord.
Those are the days gone, Mr. Chaudhary, where floods were taken into consideration by the courts and passed interim directions. Not this court. It was supposed to be dismissed at 2 o'clock. Now it is getting dismissed at 10:30, 11.
No, my lord, that I am not. Then your lordship will grant me liberty to my lord participate.
You participate. I will make it very clear. The dismissal is there, but however, the petitioner is always at liberty to participate. However, time is there, I suppose.
Yes, my lord, in 2 cases, my lord, time is there. In 3 cases, my lord, today is the last day.
Today is the last date. You extend it, give some time.
My
5
lord.
5 days.
My lord.
5 days you go issue a corrigendum.
Yes, yes.
I'll do that.
Which are the 3 cases?
The 3 cases are, my lord, item number, sorry, item number 20, 22 and
এগিয়ে দিয়ক
26.
এই গোটেইকেইটা দিয়ক একেলগে dispose. One order. Dispose of all.
20, my lord, that item number 20, the completion time was 3 months. And the work order has been issued on 26/8/2025. That time is over, my lord.
The decision to cancel was taken prior to, my lord, the period over, and your lordship will kindly notice, my lord, in this case, initially I was given time for 3 months. Now in the fresh tender, my lord, they have given 6 months time, my lord. They also have realized the mistake perhaps. In the fresh
Very
tender,
difficult. No, Mr. Bhuya will only concede to that he will give another 5 days.
Yes, yes.
By issuing of a corrigendum.
Yes, yes.
In these tender. That is his conceding. He is conceding. I am not directing him
Yes,
to for issue.
Yes, we will, my lord.
Yeah, বাকি 3টা item দেখাওকচোন।
Communicate করবেন।
Which are the items?
these 3 items are, my lord, 20, 22 and 26.
You have said 5 items.
Yes, my lord, and the 2 items are, my lord, item 20, 22 and 20 and 23. There, my lord, I have time.
We have only 3.
5 cases.
Which are the items?
Item 20,
You are in front of me is 23, 20, 22 and
25 and 26.
25 and 26.
25, 26.
কোনটোত আপোনাৰ extension লাগে?
Extension like complete na. Also what I get.
Huh?
What's that?
20
22 and 26.
and 26. Okay.
No, all these 5 petitions are heard Mr. M.K. Chaudhary, the Lineage Senior Counsel, assisted by Mr. P. Bhardwaj, appearing on behalf of the petitioners in the batch of 5 petitions. Mr. A.K. Bhuya, the Lineage Senior Standing Counsel of the Bodoland Territorial Council, who appears on behalf of the respondents. The grievance of the petitioners in the batch of 5 petitions is that they were issued certain work orders pursuant to a tender process. And as the petitioner and on 14/10/2025, a decision was taken by the Executive Council of Bodoland Territorial Council that in respect to those contracts where no work order against the scheme had been issued and where work order had been issued but the work had not started, the administrative approval would be cancelled. And it is under such circumstances the work orders so issued in favor of the petitioners in the batch of 5 writ petitions have been cancelled. And fresh notice inviting tenders have been issued. It is under such circumstances the present 5 writ petitions have been filed. The question arises in the instant proceedings as to whether this court should exercise its jurisdiction under Article 2 to 6 of the Constitution in the present facts and circumstances. It is the opinion of this court that certain material facts are required to be taken into consideration. And as such, the details against each of the petitioners are stated hereunder. Who is your prize client, Mr.?
My lord,
Who is your prize client? I put his name first.
the Padma Basumatari.
Okay, chalo. Let's have Padma Bhasu. Yes. But Mr. Zamindra Kosari has come twice.
My lord, three cases. My
Then he should be the most prized one. Anyway,
Hello, only my lord, in other cases, in these 2 cases where there is still time, the last date is 24. So in these 2 also you have also take extend time up to 24.
let me put down the facts. You take your seat. WPC number 7254/2025. A notice inviting tender was issued for construction of inverted comma Muthra FIS at Magurmari bracket headworks part bracket close under PMKSY dash HKKP for the year 2021-22 at Suklai Terfang Goresor Division bracket irrigation Goresor dated 9/6/2025. The petitioner in the instant case was chosen to be was issued a letter of acceptance on 15/7/2025. And further, the petitioner was also directed to furnish the performance guarantee as per the tender conditions. Pursuant thereto, on 23/7/2025, upon furnishing the requisite performance security, the petitioner was issued the notice to proceed with the work. It was categorically mentioned that the time of completion was 12 months. Admittedly, the petitioner herein did not start the work on the ground, did not start the work. And this aspect is apparent from the report of the physical progress given by the executive of engineer Suklai Serfang Goreswar division, which the petitioner do not contest. The record further reveals that on 4/10/2025, a decision was taken in the Executive Council of the Borolel Territorial Council, wherein, amongst others, it was decided that in respect to those work orders, decided to cancel all administrative approvals where no work order against the scheme was issued and where work order has been issued but work had not started at the site. Pursuant to the said decision, the Secretary, Boroland Territorial Council, issued a communication to the Secretary, Boroland Territorial Council. What is this? To the council head of the department, issued a communication dated 15/10/2025 to the council head of the department, Irrigation Department, BTC Kokrajhar, to cancel all tenders where work orders have not been issued or where work had not been started. Pustak. The record further reveals that in pursuance thereto, there was a verification carried out by the Irrigation Department of the BTC. And amongst the various works, the work of the petitioner was also came within the purview of cancellation in as much as there was no work started in the site. Resultantly, by the communication dated 28/11/2025, the additional chief engineer cum CHD Irrigation BTC had cancelled the formal work order issued to the petitioner. And thereupon, on 1st of December 2025, a notice an invitation for bids was issued in respect to the work, in respect to various works, in respect to 100 new SMI schemes, which included the work of the petitioner. It is further relevant to take note of that the last date for submission of the bid is on 23/12/2025. As per the note invitation for the bids dated 1/12/2025. The petitioner being aggrieved by the cancellation as well as issuance of the cancellation by the communication dated 28/11/2025, as well as the invitation of bids for bids in respect to the work for which the petitioner was earlier issued a work order dated 23/7/2025, have approached this court by filing the present writ petition. Number 27251. In the instant writ petition, the petitioner herein was issued a preliminary work order on 26/8/2025 for construction of one number of additional cross drainage bracket size 12.5 meters into 600 mm dia bracket close at S2M3D2 ERM Sukla irrigation project for under PMKSY-AIBP for the year 2021-22. Subsequent thereto, a formal work order was issued on 26/8/2025, and the period of completion was mentioned as 3 months. Full stop. In view of the decisions so taken in the minutes of the meeting dated 14/10/2025, as already stated above, the formal work order so issued to the petitioner herein was also cancelled via a communication issued on 27/11/2025, and a short tender notice was issued on 1st of December 2025. Which included the work which was allotted to the petitioner. In the said short tender notice, it has been mentioned that at 2 p.m., that up to 2 p.m. on 16/12/2025, the bids would be accepted. (7266/7253/2025). In the instant with petition, the petitioner herein was issued a preliminary work order for construction of boulder sway houses at D2 Canal from Chennai CH.5345.00 m to 5390.00 m of ERM Sukla irrigation project under PMKSY-AIBP for the year 2021-22. The formal work order was issued on 28/2025, wherein also it was mentioned that the time for completion was 3 months. In view of the decision taken in the minutes of the meeting dated 14/10/2025, the petitioner's formal work order was also cancelled by the communication dated 27/11/2025, and subsequent thereto, a short tender notice was issued on 1st of December 2025, which included the work of the petitioner, and the last date for submission of the bid is on 16/12/2025 at 2 p.m. The petitioner, being aggrieved, has approached this court by filing the instant writ petition 7266/2025. আগতো যি কথা কৈছো exactly এটো কব ইয়াত preliminary of work order issued on 28/2025 খালি এটো difference হল এটো page 15 পাই যাব এটো লকে বাকিখিনি যোনখিনি 7253 7254 যোনখিনি কথা কৈছো exactly সেইখিনি exactly 20 তাৰিখে এটো ইয়াত page 15 পাই যাব I did not say 7265. The petitioner herein was issued pursuant to a tender process initiated by the notice inviting tender dated 9/6/2025 was issued a letter of acceptance for Mutra FIS at Magurmari bracket canal and apartment structure bracket close under PMKSY this HKKP for the year 2021-22 at Suklai Serfang Goreshwar Division Irrigation Goreshwar Subsequent thereto, the petitioner, no, in the said letter of acceptance, the petitioner was asked to submit the performance security. In terms with the notice inviting tender conditions. তাৰপিছত এই ফাৰ্ষ্ট ৰিপিটিশ্যনখনৰ যোনখিনি ফেক্টছ আছে এক্সেক্টলি সেইখিনি 23(7) একে সব গোটেইখিনি একে হয় এইটো হয় এইটো হয় Now in this case this is not done under that one. Why are you enclosing the short notice inviting tender in this case also? This comes under this thing, na? This comes under the other one.
38.
Your worship, fine, my lord.
No, page 38. You agree by this one.
Yes, ma'am.
You don't require the other one. The other one is for the other works.
Yes.
This has nothing to do. It is just when you're filing 5 writ petition, this
That's what
must
I
have happened. Listen. Mr. M.K. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submitted. Petitioners in the present batch of writ petitions submitted that on account of reasons beyond the control of the petitioner could not start the work. And this very aspect can be very well seen from the physical progress reports being submitted by the executive engineer, wherein also it is mentioned as to why the petitioners in the 5 writ petitions could not start the work. He therefore submitted that the respondent authorities ought not to have therefore cancelled the formal work orders which cancelled the notice to proceed with the work or the formal work orders which have been issued to the petitioners in the present batch of writ petitions. Full stop. The learned counsel further submitted that in respect to the notice inviting tender which has been issued pertaining to WPC number 7265/2025 and 7254/2025, eto agot piece kori dibo. The petitioners can still participate in the notice in tender process, taking into account that the last date is on 21, na?
23rd.
On 23rd of 23rd of December 2025. But however, in respect to the other 3 tender writ petitions, the petitioner therein cannot participate, taking into account that today is the last date at 2 p.m. He therefore submitted that the actions on the part of the respondent authorities in cancelling the tender process, the formal work orders as oblique the letter of acceptance, and the letter of formal work as well as the notice to proceed, does not is in violation to the provision violation to Article 14 of the Constitution, in as much as the same apparently is arbitrary, unreasonable. More so, when the petitioners in WPC number 7254/2025 and WPC number 7265/2025 has another 6 months' time for completion of the more than 6 months' time for completion of the work. Per contra, Mr. A.K. Bhuiyan, the learned counsel appearing on standing counsel, senior standing counsel appearing on behalf of the BTC, submitted that these petitioners, the petitioners in the present batch of petitions, though were issued work orders as far back as on in the month of July and August 2025. Even after a passage of 3-4 months, have not started any work. This aspect would be clear from the own admission of the petitioners. The Learned Counsel further submitted that in respect to the petitioner in WPC number 7253/51/2025, WPC number 7253/2025, and WPC number 7266/2025. The work orders, the formal work orders were issued on 28/2025. And the period of completion was duly mentioned as 3 months. The Learned Senior Standing Counsel submitted that even after the period of 3 months being the period of completion, the petitioner herein have not started the work. And under such circumstances, the question of this court may not interfere with the tender process inasmuch as these works, the works in question, are funds received from the central government, isn't it?
Yes, my lord.
And funds received for the central government. And if there is any interference or a stay being granted in the instant proceedings, the money, the funds would remain unutilized. Full stop. Further to that, as regards the the petitioners in WPC number 7265/2025 and 7254/2025, the Learned Senior Standing Counsel submitted that even after a passage of 6 months, they have not, per passage of 5 months, 3 months, 4 months, they have not even started any work. And as such, the respondent authorities have rightly taken a decision to go ahead with a fresh tender process. Full stop. This court, while hearing the Learned Counsels appearing on behalf of the parties, had inquired with Mr. A.K. Bhuiyan, the Learned Senior Standing Counsel appearing on behalf of the BTC, as to whether it is possible for extending the period in respect to the short tender notice dated 1st of December 2025 by some period so that the petitioners herein can also participate. The Learned Senior Standing Counsel, upon instructions, submitted that how many days?
7 days, my lord.
By 70.
7 days. 7 days, my lord.
7 days.
7.
Submitted that a fresh corrigendum would be issued in respect to the short tender notice dated 1/12/2025, thereby extending the period for submission of the bid by 7 days.
By 7.
Full stop. In the backdrop of the above, this court now finds it relevant to take note of the relevant contentions, the submissions so made by the Learned Counsels appearing on behalf of the parties. The materials on record reveal that though the petitioners in the present batch of petitions have been awarded contracts to complete with awarded contracts, the petitioners, however, have not carried out any physical progress in those works, in the works in question. In respect to the petitioners in WPC number, petitioner in WPC number 7253/2025, 7266/2025, and 7251/2025, it is seen that the formal work order was issued on 28/2025. And these work orders were cancelled on 27/11/2025. The period of completion of the work was 3 months, meaning thereby that the work ought to have been completed on or before 20/11/2025. However, in the instant case, the petitioner in the three with petition being WPC number 8251, 7251, 7253, and 566 have not started any work on the date of cancellation. Under such circumstances, it is therefore the opinion of this court that the question of interference with the decision to go for a fresh tender in respect to the said work, in respect to the work so awarded to the petitioner in the three writ petitions being WPC number so and so, do not call for any interference. It is also seen that in respect to the writ petitioners in WPC number 7254/2025 and 7265/2025, the notice to proceed was issued on 23/7/2025. In the case of the writ petitioner in WPC number 7254/2025, the period of completion is 12 months, whereas in the case of the writ petitioner in WPC number 7265/2025, the period of completion is 8 months. Full stop. Inspection was carried out on or before 10/11, inspection was carried out pursuant to the decision of the Executive Council of the BTC and a report was submitted on 10/11/2025. As on that date, there was no physical progress. There was no inkling of any physical progress. This court also cannot be unmindful of the fact that these are projects which are funded, partly funded, fully.
Funded, my lord. It appears to be funded by central government.
These are funded by na?
Yes, my lord.
These are. This court also cannot be unmindful of the fact that these projects in question are sponsored projects. And the funds so allocated, if remain unutilized in view of not carrying out the work, the funds would have to be returned. Under such circumstances, it is therefore the opinion of this court that the decision so taken to cancel the letter of acceptance as well as the letter to proceed with the work in respect to both the petitioners in WPC, that is in the case of the petitioners in WPC number 7265/2025 and 7254/2025 do not call for any interference. Accordingly, the present batch of writ petition stands disposed of with the following observations and directions. This court does not find any merit in any of the 5 writ petitions so filed before this court. Number 2. The dismissal of the writ petitions being or dismissal of the 5 writ petitions, and accordingly, all the 5 writ petitions stands dismissed. Number 2. The dismissal of the instant writ petitions, however, shall not cause any prejudice to the petitioners to again apply as per the notice inviting bid dated 1/12/2025, as well as short notice inviting tender dated 1/12/2025. Number 3. Taking into account the submission of Mr. A.K. Bhuiya, the learned senior standing counsel, that the BTC authorities would be issuing a corrigendum, thereby extending the period of submission of the bid in respect to the short notice inviting tender dated 1/12/2025 from 16/12/2025 to 23/12/2025, comma. This court further observes that the petitioners herein, petitioners in WPC number A18 Konde, 7251, 7266, and 7253 would be at liberty to participate in the said tender process. If filed within the extended period as submitted by Mr. A.K. Bhuiya, the learned senior standing counsel. First,
Deeply obliged.
The refund, my lord,
Eh?
observation resolving the refund.
you will get the refund.
This has been taken for it. Obliged, man.
Okay, let us put it. Then if I put it as his submission, then he can't even file an appeal. Mr. M.K. Chaudhary, before parting with the record, this court, however, finds it very pertinent to take note of a submission made by Mr. M.K. Chaudhary, the learned senior counsel, appearing on behalf of the petitioners in the 5 writ petitions. The learned senior standing counsel submits that the respondent BTC authorities, having cancelled the notice to proceed, formal work orders in the case of the present petitioners, are duty bound to refund the
Absolutely.
performance security. Mr. A.K. Bhuiya, the learned senior standing counsel, submitted that upon due application being filed, the same would be refunded to the petitioners. Taking into account the said submission, comma, this court would not like to pass any further orders, however, would observe that upon such applications being filed, comma, the performance security be so submitted by the petitioners in the present batch of writ petition in respect to the earlier work orders / notice to proceed issued be returned to the petitioner.
Obliged.
Lordship, in this case, actually, copy was not served to us, Lordship. So, Lordship, let me allow, let him,
And election officer.
so, Lordship, within a week, I will bring the instruction, Lordship.
It has been submitted by Mr.
G. Sharma,
G. Sharma, who appears on behalf of the
respondent
Foreigners
number 1
Tribunal.
and 5, Lordship.
Huh?
Respondent number 1 and 5.
Document number 1 and 5, then no copy of the instant writ petition has been served to him. Full stop. Taking into account the above, list this matter on 19/12/2025. Full stop. For motion, the counsel appearing on behalf of the petitioner is directed to serve extra copies of the instant petition to Mr. G. Sharma during the course of the day.
Name of the SCFT may be shown in the
And the
corpus.
name of, and the registry shall indicate the name of SCFT in the court list. You just find out if the
Yes,
copy is
Lordship.
given,
I have,
find out why it has not been referred till now.
yes, Lord.
And if it is referred or not.
Yes, Lord.
Because there is already an order passed.
Yes, Lordship. Yes, Lordship.
Keep an item to your notes and instructions to withdraw this lordship with liberty alone.
Why?
Liberty, my lord.
What
already-
liberty?
Liberty lordship, lordship. please to come
Liberty,
to
I
page
don't
number
give
39,
so-
your lord.
So easily I don't give you liberty.
Lordship, please to come to page number 39, your lord. This is with regard to auction of red sandalwood lordship by the forest department in 6 lots.
Huh?
This particular one, auction of red sandalwood in 6 different lots. We participate in the same. your
Page
lordship.
39,
Page 39, your lord.
E9. Yes. Where? Which clause?
38 lordship will find clause 5 eligible.
Clause 5.
Page 38 lordship will eligible.
5.
Lordship,
Yes.
please to come to clause 5, F, G, H and K. Lordship,
H.
they have put in a clause whereby we need to be registered member of the Export Promotion Council for Handicrafts or with any state handicraft board. The bidder should have registered artisans from the Office of Development Commissioner Handicrafts or State Handicraft Board. The bidder should have minimum 3 years of experience in manufacturing and export of value-added products of red sandals to sandalwood. The bidders will submit a requisite document in support of this claim, lordship. We are agreed by this clause, your lordship. The lordship will grant us liberty lordship in the future area of tender is floated and it contains the same clause, lordship, so that the doctrine of res judicata does not apply. Lordship. You can challenge it in the future, lordship.
Why?
Any other future tenders, your lordship.
That is a
As of
separate
today,
cause of
lordship,
action.
because we missed the bus, lordship, that is how to withdraw this case, your lordship.
You say that you don't know, you are not pressing the petition in view of that,
Lordship,
or you want to withdraw it without prejudice.
lordship,
That's all.
lordship.
Nothing more
Otherwise,
than
lordship,
that.
this is
But
not-
why should I give
this is
liberty? No liberty business.
Lordship,
Liberty is different. Liberty is you again file. There's a difference. But withdrawal without prejudice is different.
There is a case where they, with their eyes open, participate in the same tender, my lord. Now they're challenging the terms of tender.
Because that is a lordship of withdrawing lordship, but
Anyway.
this clause has no rational nexus with the object. Auction means highest bidder. They cannot.
Can they not participate? No, I am asking you. Can they not participate in a tender condition, a tender, and then challenge the terms and conditions?
My lord, I have checked, my lord, judgments, my lord, in this regard. There are judgments, my lord, they can. But in Ronak International, my lord, there is a observation of the Honorable Supreme Court, the last paragraph, that at their behest may not be,
It cannot be done.
may not be.
Lordship in NHI versus Jhansi Corporation, lordship. NHI versus Jhansi, that construction project, lordship, the Supreme Court states that if you do not participate, then you also cannot challenge.
Yes, there are judgments to that
There
effect.
are-
But that was a judgment on another aspect. The aspect is, no, the aspect is different. If you don't participate, you may not know certain illegalities. But terms is a different thing. A term, how a particular term is being interpreted, there might be an illegality and you cannot challenge if you don't participate. But on the face of it, if there is no second conclusion can be drawn, then, just for example, 5F, the bidder should have registered member of Airports Council, Exports Council. It is very clear. It cannot have any ambiguity for any subject matter of any interpretation,
But lordship with regard to auction, lordship.
whatever may be. But this clause is very clear.
That was not quoted by the handicraft department, your lordship. That
It's a sandalwood, my lord, we wanted to regulate after sale also, my lord.
No, I'm not on that. I'm giving you an example. Taking into account the judgment of the Supreme Court. This doesn't have any ambiguity. So, unless you participate, you cannot say. What is the illegality? Means if there is an ambiguity out there that they will submit a particular document in a particular manner, which you think that it can be submitted in this manner and they say something else. Then later on, you can very well say that this term cannot mean. And if it is means also, this is illegal. Then you can.
Yes.
Anyways, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner and Gautam
Sure.
submits that the petitioner and submits that as the tender as the period during which as the why are you withdrawing it?
And auction process is already over, my lord.
As the tender process is already over, comma, the petitioner would like to withdraw the instant writ petition without prejudice. Mr.
All the rest.
P.N. Goswami appears on behalf of all the respondents. First, taking into account the above, comma, the instant writ petition stands closed on withdrawal. However, the same shall not prejudice the petitioner in future.
Obliged.
The withdrawal as a part of the report.
The copy of the instruction provided to the counsel for the petition is kept on record and marked with the letter X.
Obliged.
The section is. But the regional transport authority,
What happened to the earlier one?
earlier one is pending now. They have filed a affidavit. They have filed a reply. They have filed a reply with them. Meanwhile, they have taken the decision.
They have?
Yes, meanwhile, they have taken the decision, RTA board says that your vehicles should be off-roaded from that particular routes. And that route will be only allowed to be plied by the electric vehicles. It will be reserved for electric vehicles only. But at the same time, all other vehicles, either petrol vehicles or diesel vehicles operated by others, those will continue to run in the same route. They only outside.
Where is that impugned communication?
Page 87, man.
Page 87.
Annex of 7. Fine. 1st of November 2025.
This is one vehicle.
Right, this is. So, people find that, about this table, they say accordingly, second, which refers to the subject, so and so, RTA Board Transport Authority, dated 13/10/2025, issued under the purview of section 72 of the Motor Vehicle Act 88. I am directed to inform you that as per the Green City Bus Road Initiative to promote cleaner, safer and more commuter friendly urban transportation, diesel fueled city buses will be phased out from city bus routes number 26 Hanapara, so and so, and route number 36 Bosistha, only to Dharapur, so and so, which effect from 1st January 2026. Accordingly, here mentioned vehicles will be currently flying in 26 have been mandatorily required to be rerouted in any one of the following routes of your choice as per the recommendations made in the joint inspection report submitted by members of the District Road Safety Committee, so and so, and they have shown this. Therefore, you are instructed to appear before office of the undersigned on 22/12/25 along with the original.
So what is wrong?
Sorry?
What is wrong?
Wrong is, my lord. In such cases, the law is very clear. Kindly see rule 99 and 100.
Rule.
Rule. Motor Vehicles, sorry, Motor Vehicles Act, section 96, 99.
Rule 99.
Section. Chapter 6.
Yes.
Article 5. Preparation and publication of proposal regarding road transport service of a state transport undertaking. Where any state government is of opinion that for the purpose of providing an efficient, adequate, economical and properly coordinated road transport service, it is necessary in the public interest that road transport services in general or any particular class of such service in relation to any area or route or portion thereof should be run and operated by the state transport undertaking, whether to the exclusion, complete or partial, for other persons or otherwise. The state government may formulate a proposal regarding a scheme giving particulars of the nature of the services proposed to be rendered, the area of route proposed to be covered, and other relevant particulars respecting thereto, and shall publish such proposal in the official gazette of the state, promulgating such proposal and in not less than one newspaper in the regional language circulating in the area of route proposed to be covered by such scheme, and also in such other manner as the state government formulating such proposal deem fit. Notwithstanding anything contained in subsection 1, when a proposal is published under that subsection, then the date of publication of such proposals, no permission will be granted to any person except a temporary permit during the pendency of the proposal, and such temporary permit shall be valid only for a period of 1 year from the date of the issue or till the date of final publication of the scheme under section 100 earlier. That kindly see 100. Objection to the proposal. On the publication of any proposal regarding a scheme in the official gazette, and in not less than one newspaper in the regional language circulating in the area or route which is to be covered by such proposal, any person may, within 30 days from the date of its publication in the official gazette, file objections to it before the state government. The state government may, after considering the objections and after giving an opportunity to the objector or his representatives and the representatives of the state transport undertaking, be heard in the matter, if they do desire, approve or modify such proposal. The scheme relating to the proposal as approved or modified under subsection 2 shall then be published in the official gazette by the state government making such scheme, and in not less than one newspaper in the regional language circulating in the area or route covered by such scheme, and the same shall thereupon become final on the date of publication in the gazette, official gazette, and shall be called the approved scheme, and the area of route to which it relates shall be called the notified area or notified route. Provided that no such scheme which relates to any interested route shall be deemed to be an approved scheme unless it has the previous approval of the central government. Notwithstanding anything contained in this section where a scheme is not published as an approved scheme under subsection 3 in the official gazette within a period of 1 year from the date of publication of the proposal regarding the scheme in the official gazette under section 1, the proposal shall be deemed to have lapsed. So, explanation in completing the period of 1 year referred to in the subsection. Any period or periods during which the publication of the approved scheme under subsection 3 was held up on account of any stay or injunction by the order, any court shall be excluded. Not at all complied with 90 or 99 or 100. Nothing. And then Lordship will see 101, 103 section. If such schemes are floated or notified or finalized, notified, then 103 may come into. So that is 103 months.
Now, what happens if your permit is not renewed?
The permit has not been, some permits are beyond 25, 26, 27. It is there. Some are expiring on 31st of December. In that case, they have forcefully taken undertaking. That you will have to remove it from that sign undertaking, we are extending, renewing the permit till then, not beyond. This is how they are pressurizing.
Now, tell me, what is the right to get the renewal of the permit?
Now, look, my right is that the scheme of this act is such that whenever a bus is allowed to fly in a particular route, we are to conform to many requirements. And ultimately, the permit is issued on a route specific. A specified road only it is issued. And to that extent, we are financed by the other authorities also. Because going by the viability of the road, possibility, then the whole, we take finance. Authority will run finance on us. And that's how it runs. Unless we can show the permit, no authority will come forward and run from it. Because without a permit, the vehicle is not allowed and therefore no.
It's okay, but what is your right to renewal?
Right to renewal, kindly see this provision. Otherwise, what is the rule of review? If I have not violated any rule, any condition, then I have a right to get it extended. If I have done something wrong, of course.
The right to permit is where?
Yeah, duration of renewal of permit, can you see 81?
Page 81.
No, section 8. Page 74 in this book.
A permit other than a temporary issued under section 87 or specially issued under 830 months shall be effective for a period of 5 years. So you have a permit for 5 years.
5 years.
Provided that where a permit is countersigned under subsection 1 of section 88, such countersignature shall remain effective without renewal for a period as to synchronize with the validity of the primary. A permit may be renewed on application made not less than 15 days from the date of the expiry. Notwithstanding the original term, as the case may be, entertain an application for renewal of a permit after the period. As the case may reject an application of a permit on one of the financial condition of the applicant as advanced here has been punished twice, plying any vehicle without payment of tax, without payment on an unauthorized route,
Section 4 says
make
grounds
unauthorized trips.
which they can reject. So authority, as the case may be, may reject an application for the renewal of the permit on one or more of the following basis. A, financial condition of the applicant as evidenced by insolvency or decrease for payment of sales pertaining unsatisfactory for period of 30 days prior to the date of consideration of the issue. The applicant has been punished twice or more for any of the following offences within 12 months on the from 15 days prior to the date of consideration of the application committee. The result of operation to stage service like a business. Buying any vehicle without payment of tax due. Then 2, without payment of the tax during the grace period. Following the tax grace period. 3, on any unauthorized road. Unauthorized road. Making unauthorized trips. These are the conditions on which they can control.
So your therefore submission is that section 99 onwards provides a scheme by which if there is a question of it is to be run by only by the state transport undertaking and there is other people who are there, you have to float a scheme see objection, and thereupon act. Here, the scheme has not yet been floated. And in absence of that, it cannot be so.
Yes.
That's your case.
Right, like the crux is that, this is the crux. There is a definite law providing how to go. The authority totally ignored those laws. And they say, we are declaring this as green route. Those 100 or some buses, electric buses, will be available there. So you cannot, will oust you. That is very arbitrary. Unless you go in accordance with law, hear us, take the call finally, as the law wants. Why? Because it is to exclude us only. But all other, the green route, logically, a green route can be called a green route when it will be open only for green way. No other way. To the exclusion of all other way. Even in Delhi, Bombay, it has not been possible. Those BS4, BS6, BS3 buses even are allowed there. That to be very practical. CNG in Assam is not practical. It failed. It failed. And electric buses, Lordship may also appreciate, I may tell you Lordship. Even earlier also they introduced some electric buses, those failed. And more particularly during the winter, I mean the summer, rainy season, those cannot go in the water. And the drivers themselves, they report to our client that they will have to stop the bus because once only they can charge it in the morning and it will run till 7:30 evening. Thereafter they cannot. Our buses fly till 11 o'clock night. They are catering to the needs of the people.
But are you permitted to fly till 11 o'clock at night?
Well,
Can you fly till 11 o'clock at night?
well, now it is of
The
course.
permit specifies how many routes you can make.
True, well, that is how.
Then
Nowadays, the government has given the time.
if you go beyond that, then the problem arises.
If we go beyond the time, the government can take action. But now the government says that.
Yes,
let also you-
Mr. Nath, what is it?
Well, first of all, Lordship may kindly see the 5/4/2025, the resolution that is under challenge in this case. In fact, challenging that resolution, another writ petition is filed that is pending. In that writ petition, my lord, we have filed a affidavit bringing all the minutes and the decisions, the backgrounds, why that decision has been taken. We have filed.
No, no, decision very well. You
No.
have a very good decision
Lordship,
that it should be made green and all.
my lord.
But in doing so, are you not required to follow the mandate of 99 to 102?
Section 99, my respectful submission, my lord, it will not come.
Why?
It will not come because kindly see, my lord, the language of section 99 and 100 is very specific to a scheme where just I'll read the first portion, my lord. My lord, where any state government is of opinion that for the purpose of providing an efficient, adequate, economic and properly coordinated road transport service, it is necessary in the public interest that road transport service in general or any particular class of such service in relation to any area or route or portion thereof should be run and operated by the state transport undertaking. If specifically state take a scheme that it will be run by the state or by any other agency under the state. But here that is not the case. My respectful submission is, my lord, we have my lord identified that particular two roads as green road. Green roads, two roads, route 23 and route 36. Our initiative is to declare them as green roads. But we have not stopped them that you can't fly there. And the only state will have a scheme. This scheme has been introduced by the state that we will only manage the transportation in that particular road. That is not the case here. Well, in fact, they were called, they attended the meeting, they were given the option that you change your from diesel, if you shift to CNG, you can also fly there. What we are doing it, my lord, only CNG or electric EV vehicles we are allowing in that particular two roads. These things are, these things are coming up. We have given them option.
But have you notified it?
No, Malad, since
That you are going to only have this from 1/1/2026?
Malad, yes, these are Malad 5/4/25 meeting was held. Then in the month of July.
No, it is Quad M.
Yes.
But have you notified all people?
Malad,
Because here we are concerned that you are going to, tomorrow you are saying that this is a green route. You are saying that it is a green route and it will be now you'll be now using your state transport undertaking buses, those green buses.
even if Malad, we have given the option to the petitioners that if they are ready with the CNG buses or electric buses, they can also come. But they have been writing, Malad, they have said that they are not willing to change their mode to CNG. In the affidavit, we have annexed that Malad, in the other petition, we have filed the affidavit. We have annexed that.
What happened? Yesterday, the petition was pending.
It was listed. They took time. Malad. The petitioner took time.
And when is it fixed?
After a week. Well, in fact, there is a letter submitted by the secretary of the petitioner association that they are not willing to change their mode to CNG. Well, possible or not possible, ultimately it's a matter of policy decision. Well, kindly see, they attended the meeting 5/4/2025. Lordship in the writ petition at page 111. And my respectful submission, therefore 99 doesn't come here. Section 99 doesn't come. Now kindly come to, it starts at page 113, the resolution starts, relevant is 116, 116.
Where?
Serial
Page?
2, serial 2, 116, page 116, serial 2. The topic was, Malad, designation of Guwahati city bus route number 23 and 36 as green routes and renewal of stage carriers permit of diesel operated buses plying in Kamrup Metro. Then they have taken this decision, Malad. The petitioners, they also attended this, Malad. Yes. The renewal of stage carrier permits.
You have now taken a decision that the stage permits will be renewed only up to
December.
First, you are making it 6 months.
Up to December.
All stage permits.
No, for this, Malad, here we have
No,
taken
the
a decision.
renewal of stage permits for these buses shall be granted on a 6 months basis.
Yes, Malad.
Similar to the process for diesel operated buses on other routes. Means, are you giving it for 6 months only?
For the buses which are running in these particular two roads.
No, sir, similar to the process for diesel operated buses in other routes. What do you mean by that line?
6 months was it? That I'll clarify, Malad. That I'll clarify. But in this route, for this,
By the time you clarify which state,
no, Malad, we are concerned with route number 23 and 36, Malad.
understood.
So
but
I am
the fact
placing
is- but the
what has
fact is
happened.
why I'm saying it. The next option is, however, the validity of permits for buses operating on route number 23 and 36
Lordship.
must not extend beyond 31 December 2025.
Yes,
The
Malad.
DTO secretary shall ensure strict compliance with this.
Yes.
How can you curb it when the mandate of the statute says something else?
Malad, this is a purpose, Malad.
No, the purpose may be very holy, very good. I understand. But the law, you have to take a, kindly see 81, section 81. It says that the permit will be there for 5 years.
that I have seen.
You can reject the permit only for all these reasons.
Malad, those are conditions of permit if there is some violation, Malad, but here is a case, Malad. The authorities' intention is very clear in this.
No, Mr. Nath, I understand it. It's a very noble attempt. There's no quarrel with that proposition. There's no quarrel with the proposition unless there are orders passed by the division bench out here on a PI, taking into account the pollution, that all the buses stop, which was done in Delhi by the Supreme Court. This aspect is different. Otherwise, are you not required to follow the mandate of law, which is there in 99? You are having a scheme. Kindly see 105. See 105, why I'm saying so.
99, my lord.
No,
my as per
99 is
constitution
okay,
doesn't come.
105, see 105.
Lordship. Principles and method of determining compensation and payment
Where in
thereof.
exercise of the powers conferred under clause B or clause C of so and so, any existing permit is cancelled, or the terms thereof are modified.
My lord, this is not a case of cancellation, my lord. We are not cancelling them.
No, or modified. Why are you not reading it?
My lord, we
There
are,
shall be paid by the state transport undertaking to the holder of the permit. Compensation, the amount to which shall be determined in accordance with subclause sections 4 or 5 as the case may be. 4 is where in exercise of the powers conferred by clause B or subclause A of so and so, any existing permit is cancelled or the terms thereof are modified so as to prevent the holder of the permit from using any vehicle authorized to be used thereunder for a full period from which the permit would there otherwise be effective. The compensation payable to the holder for each year affected by cancellation shall be computed as under. Now, do you say out here that look here, granting a permit to run is another thing,
Lordship.
but to granting a permit to run in a particular route is another aspect. Is
No.
it something like that?
My lord, we are,
What is this permit business?
permit business is to run in a particular route.
So therefore,
My lord,
how do you take care of 81 then?
But we are rerouting them. We are not cancelling their permit. They will ply their vehicle. Only we have said that this not in this particular route. We have given 10 options. Out of 158, my lord, already 36 have gone to the other routes. And the other persons, my lord, individual notices we have issued that out of 10 routes, you choose any one of them. On first come first basis, we'll give you. But they have filed a representation that was considered, my lord, and ultimately, my lord, we are not cancelling their permit. We are not stopping them from plying. Even in this particular route number 23 and 36 also, they can, my lord, ply. They can have their vehicles, my lord, but only if they, my lord, install CNG. We are stopping only diesel vehicles. And the purpose is very clear, and kindly that.
No, I understand your purpose. There's no quarrel with that. I also want to side with you, taking into account the number of vehicles out there would be reduced. No question with that. But the fact remains the law is there in that regard. 99, you have to show that 99 under no circumstances apply.
99 doesn't come, my lord.
Why?
99
Because Mr. Nath says so?
No.
Or is it
99
the provision does not apply?
No, 99, my lord, the language is very clear because we are not, my lord, we have not said that we will apply. We have a scheme that only the state will control the entire transport system in that particular route. We have not said so. They are also permitted, my lord, they are also allowed. There is no such scheme that we have taken over that particular route and nobody else, only the state agency, we will run. We have
So your case is this,
that if
that we are not rerouting them. We are not doing anything else. We are not even asking that it should be only the state undertaking will be running. Anybody can run.
anybody can run.
Even the petitioners can run, provided
The CNG.
they have the CNG.
Yes, that is my case.
What is the power? You are not rerouting them. Understood. But you should not therefore make a submission that you are not rerouting them.
My lord, if they
We are only stopping anybody who is otherwise flying out there without
my lord, this has
bus, without.
this has two sides. My submission has two sides, my lord. Number one, my lord, we are permitting CNG buses or electric vehicles in that particular two routes. Secondly, my lord, when they have in writing said that we are not agreeable to convert our vehicle to CNG, ultimately the natural corollary, my lord, we have to give them option that they should go to other routes. Ultimately 10 routes we have given in the notice, my lord, we have given them 10 routes that you choose any one of them. The page 87 lordship has seen. And my lord, this particular decision of 5/4/25, it was subsequently on 5/7/25 there was a meeting. Then 5/8 they have filed a representation. It was considered in 5/8/25. Ultimately,
There's a different aspect.
so
I'm
these
not on
things
that.
these things are going
But
on.
how do you
not-
take care of 99?
But
Unless you say that this is not a case of rerouting.
No, if,
It is a case of cleaner environment.
Malad, it is a case of cleaner environment, but we have said.
We
that
allow
it's a-
them also. So therefore, you may very well say that it is not a case that it is only putting only the state transport undertaking there.
Malad, because the records which are available with, Malad, with me.
It is available to every person
Yes,
who has a. So therefore, your basic idea is nothing to do with state transport undertaking, because 99 in the scheme is in respect to the state transport undertaking.
yes, Malad.
Is it your submission?
Malad,
Or am I making the submission for you?
yeah, Malad, that is my submission. Therefore, Malad, when Malad in writing they have
So
said.
therefore, don't make the submission of rerouting. The moment you are making rerouting, it has a big problem with 99.
Malad, ultimately, when their vehicle is diesel,
You have given them.
we
It's
have
a different
given them
thing. You can
option.
very well say that, look here, we have given them alternative routes to take care of their livelihood.
That's true. That is what we have done,
That is the livelihood question we have duly taken note of.
Malad.
But the fact remains is our basic intention is not only state transport undertaking, because chapter 6 is only in respect to state transport undertaking. Make an argument to that effect. You're not making that type of argument.
Malad, that is my, Malad. I have
How
said
am
that-
I going to have you
No.
tomorrow, Mr. Monto will say, look here, this particular judge is helping the
No,
other side.
No, no,
He
Malad,
is
that is,
telling what is the submission required to
Malad, that
do.
is why,
It is
that,
never the case also.
no, that is why, Malad, my submission, Malad, is that 99 is not applicable here because we have not made any state scheme that only state will run the vehicle here. That is why 99 is not applicable.
Let me make that submission.
That is what, Malad, I'm
We have the
submitting.
submission that we are rerouting them.
No, Malad, we have at the
Doing
same,
one day. Your
have-
basic submission is, look here, we have nothing to do with the state undertaking. It may be run by anybody, but it has to be run. If a bus is run, we run it as without a diesel.
without diesel, that is what the policy is, Malad. That is what the decision is. And kindly see, 5825, Malad, the minutes in the writ petition they have annexed.
So from where do I get that decision? That they can very well run without it, without a
Malad,
CNG also.
If for a moment, Malad, this is a part in the affidavit filed in the other case. Since this case is not here, I'm just placing it, Malad. So,
Let us have this tomorrow.
Malad, just for a moment, if
We'll
Lordship
have this
kindly,
tomorrow, Mr. Mohanto.
If
Along with
Lordship
that,
kindly-
I bring that other one.
it is. Kindly see this letter, Malad, their letter. They have refused to convert their
No,
vehicle.
we'll have it tomorrow.
Yes, Malad. Tomorrow with the other petition, Malad. With the other petition, Malad, so the affidavit can be, I can.
That is the main reason.
Yes, Lordship.
So you can do it. Taking into account the instant repetition is connected with WPC number 6117/2025. And an urgency has been expressed by Mr. KK Mohanto, the learned senior counsel, lists the matter tomorrow, the present repetition tomorrow for motion along with WPC number 6117/2025.
Lordship.
Improve your arguments.
Lordship.
Improve it in that
Yes, yes.
manner.
Lordship.
You have to say that chapter 6 does not apply.
I'll see. Lordship. 99 to apply.
Yes, Mr. Dinath, what is this matter?
Amato.
What is this matter? You're telling a award? Huh?
The workman has been dismissed.
Challenging the award of the industrial tribunal.
You are for the
I am for the.
workman?
I'm for the workman.
Very strange. Mr. Datta doesn't appear for this workman normally.
Both the sides.
Huh? No, no, no. He's an expensive lawyer. Isn't it, Mr. Mumbai? He doesn't appear for this big companies.
They're not a correct notion.
Huh?
It's not a correct notion.
Absolutely. Till now, I have taken around 8-9 matters of Mr. Datta. All he has been appearing for the management.
Well, Lord, here your lordship will find there is no charge against him.
Which tea state is this? Matak.
It's the Motok district.
This must be somewhere in Dibrugarh. Dibrugarh, Tinsukia.
Yes.
Seeing the council who is representing the respondents, petitioner and that. Dibrugarh, na?
Dibrugarh, Madam.
Dibrugarh. Lord, the entire case may be heard on some other case, maybe.
Huh?
Entire case may be disposed of.
Not today.
No.
We'll have it. Have you vacated the land?
That instruction, my lord, I'll have to take.
Get your instructions. You can't retain it if you have been terminated.
The charge you'll will find is a general notice was given to all the workers. And that becomes the charge, and the MW one in his cross-examination, he has stated that I did not issue any notice to him, nor I did give a notice to vacate the land. And the construction was not under after that notice, it was way back before.
When were you terminated?
That was on
1/4/2007.
2007, yes.
So what is the next thing I can do?
No, my lord, whether the award.
What is your age?
My lord, let me get instruction on all that.
Get your age. We need to finish this type of matters in Silchar. You don't put the age also in the affidavit. You see what type of affidavit is this?
Let me check.
My goodness.
He's at that relevant time 58.
Huh?
2018.
You are 58. So question of reinstatement doesn't arise.
Whether below the entirety of the thing is correct, there is no charge against him.
No. Question of reinstatement won't arise. Taking into account the standing orders. So the only question left is here is for packages.
That's true.
So the reinstatement because he was 58.
Yes,
Right.
that.
And I think the standing orders were there for the.
Yes.
You had a standing order which was making it 60.
60.
So this period is already over. So the question of back wages doesn't arise. Only question is as regards back wages, if any.
So,
Chalo. Heard Mr. S. Dotto, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner, and Mr. D. Nath, the learned counsel who appears on behalf of the respondents.
One, Madam.
Respond number 1. The present petition has been filed challenging the order dated, the award dated 6/10/2017 passed by the Learned Industrial Tribunal at Dibrugarh in reference case number 1/2015, whereby the reference case was decided against the petitioner. Full stop. It is seen that at the time when the writ petition was filed, in the year filed, comma, along with an affidavit, comma, verified by an affidavit, dated 12th of March 2018, the petitioner has been shown to be of the age 58. Full stop. Therefore, the question of reinstatement of the petitioner as on date does not arise. The only question which therefore arises is if there is any interference to the impugned award. The question of backwages may arise. First, taking into account that the LCR has been received, list this matter on 3rd of February 2026, on which date an attempt shall be made to dispose of the petition.
Lordship.
Oh, your matter. This subsidy. Fix one. List the matter for hearing with that. Heard Mr. So-and-so appearing on behalf of the petitioner and Mr. H. Gupta, the learned counsel, appearing on behalf of the respondent. Those of taking into account that the pleadings are duly complete, issue rule, returnable, issue rule. Full stop. No additional, there's no necessity of making any additional service of notice. First of list the matter for hearing in the usual course along with WPC number.
Lordship, this matter, one affidavit was filed by the respondent number 7 on yesterday, Lordship. So we need some time, Your Lordship, to file our reply in this.
Your file affidavit.
Lordship.
See? Nowadays the PNRD department is hyperactive. What is your stand?
Lordship, I have.
Let us stay.
Lordship,
Let us see.
our stand is that as per comparative statement, bidder and the demand draft name does not match. Court is beside this one.
Why are you paying for the respondent, private respondent? What is the name of the petitioner?
Abdul Salam Pradhan.
Mohibul Haq. You are Abdul Salam Pardhani.
But in demand draft, their name is Mahibul Pradhani. So-
Peter and DD name does not match. So that has gone for a thing. So we therefore interfere. We interfere with this thing because the DD name, I've already taken note of that judgment in the BTC case. Na? There also the same reason was assigned. Because the tender condition, this is as per clause 5 and 8.
No, that's it.
What is the tender condition?
That's
Is it mentioned anywhere that the tender, it has to be that, where is the tender condition?
Page 28 and 29. This is the part of.
Mr. Counsel, you have the biggest problem. Why you are not enclosing the entire translated copy? Huh? This is not, you are not relying on the main, so we dismiss you. You have a good case. I have delivered many judgments on this aspect. You don't want your client to succeed.
We'll file the detailed.
Unnecessary, don't file replies. You need to file an additional affidavit bringing the entire translated copy. Have a judgment of this. I pass a judgment. Ask the. She's there. You were there, na? In that BTC matter. BTC, you were there. You were also there as a PNRD. Remember? Where Mr. K. Sharma is appearing. There were 2-3 writ petitions filed whereby he did not, what you call the demand draft was not in the name of the bidder, but it was in the name of somebody else. Remember? Following the judgment of Justice Manish Chaudhary, I have also held that it was not the requirement. You had to get the money. That was the main, that is the main reason
That's it.
for not giving it to him. Isn't it?
That's it.
This is the only reason that.
Only
Yeah.
reason this is.
You have a good case, but you don't want to delay it. Huh?
Agency is there also, stay is there.
Yeah, you could have got that order. After reopening, if I don't sit, the matter would get delayed.
I think you.
Eh? Not 19th. You should have filed that. She also knows the judgment. Ask her. And ask the BTC councils. They know. Or Mr. K. Sharma. He has that order. Where passed. Amata to us, na? We also have it. You can ask them. They will give it. Shall- It has been submitted at an affidavit. এই কেতিয়া আছিল? This came on last on 10th. Anyways, we'll get the order from them. It has been submitted by the learned counsel appearing on behalf of the petitioner that the respondent number 7 has filed an affidavit in opposition. He would like to file a reply. Taking into account the above, list this matter on 9th of January 2026. In the meantime, the reply be filed. Interim order passed earlier shall continue till the next day. এখন ঘুরাই দিব, হ্যাঁ, madam?
May I please go? In this case, the petitioner has paid two order. They have challenged two order basically. One 29/7 2020.
Wait. They don't seem to be interested in doing the matter, isn't it? Today,
Lordship, already matter has become infectious, Lordship,
see,
because
something is there.
two order challenge, Lordship, 29/7 2025, whereby the so-called suspension order was passed.
Already passed
That
an
has-
order on Iman, thereby putting the petitioner as well as Allah and the Halaya for a period of year. Mr. R.B. Phukon has one was the show cause notice dated here, which in view of the subsequent, the petitioner have already taken recourse to challenge. But as regards the communication dated whereby the respondent has suspended the supply of material, there appears to be no answer.
That has already tender cancelled.
With reference to the NA had decided to cancel the GEM contract dated so-and-so for supply installation of so-and-so in Iman. Violation may warrant such. Okay, so we've cancelled it, so
Yes,
the
Lordship,
question
if
does not
they agree,
arise.
Lordship, they have to challenge.
Huh?
If they agree, they have to challenge.
Miss so-and-so appears on behalf of the petitioner. You are appearing for the petitioner? Are you appearing for the petitioner? Your name is there in the list? Okay. Appears on behalf of the petitioner. Mr. K. Kolita appears on behalf of the oil. Miss So-and-so, the learned counsel appearing on behalf of the petitioner, that's against the order dated 10/10/2025. The petitioner has already approached the appellate authority. She further submits that though on 1/12/2025 a contention was made that the respondent Oil India Limited have not suspended the supply of the materials. A submission was made that though the petitioner was blacklisted, but there is no answer in the affidavit in opposition insofar as the challenge to the communication dated. What is the date?
2/7/2009.
2/7/2025. However, Mr. K. Kolita, the Learned Counsel, Standing Counsel of the Oil, submitted that the contract as regard contract with the petitioner dated 3/3/2025 have already been cancelled. And in that regard, a communication has been placed before this court dated 12/12/2025. The same is kept on record and marked with the letter X. Ms. So-and-so, appearing on behalf of the petitioner, submits that the petitioner therefore would not like to further press the instant writ petition. But the withdrawal of the instant writ petition should not prejudice the petitioner to assail the communication dated 12/12/2025 if so advised. Taking into account the above, the instant writ petition therefore stands closed. The closure of the instant writ petition, however, shall not prejudice the petitioner to assail the order dated 12/12, communication dated 12/12/2025 if so advised.
Hello.
Anything more? Okay. What is this, Ms. Roy?
Receive instructions, I have already. There is some chaos, whether the area falls under Gauripur Anchalik Panchayat or Dhubri Municipal Board. So for that purpose, we have already sent a letter to the circle officer for survey and submit the detailed report.
Is the circle officer party here? Why are you not taking action? Ms. N. Bora appearing on behalf of the PNRD.
And the president and the secretary of the Kolimari Gaon Panchayat, that there is no such notification in this regard, whether the area falls under Dhubri Municipal Corporation.
So they are therefore asking the circle officer.
The instruction is going on, Milo. So some
Construction of what?
all,
Of?
boundary wall, Milo,
By?
by the Dhubri Municipal Corporation, by the Dhubri Municipal Corporation.
Who appeals for Dhubri Municipal Corporation? Has a notice been issued? How can the service be meted out upon respond number 8? Tell me.
Yes, I filed affidavit, Milo. Those the service.
Very well. But what is this address? See the petition. Who is respond number 8?
Dhubri Municipal Corporation.
And then?
Representative. Was received the notice was received by.
I issue a letter to the Guwahati High Court. Have to, yeah. I said the Guwahati High Court, Guwahati. Who will get the letter? Tell me. Who will get the letter? Guwahati High Court, Guwahati. Is there not requirement of somebody to represent? Who is representing? Huh? Understood, but who is representing? Whom should I direct? Have you looked into the Assam Municipal Corporation Act? Possible? You are such an expert on civil law, is it possible? You are appearing for whom? Madam? What is this? So you are supporting the case of the petitioner?
Yes, Lordship, then that area does not fall under municipality. It was informed by the rescue number 5 to.
Okay. Now,
There was no such notification as per his information.
there is no
There was
notification. Madam, you do one thing, you file an IA or do something so that make respondent number 8 properly. Make it represented by the executive officer. Then we ask them to take a call. Then I can pass some interim order. I can't pass an interim order against the municipal corporation like this. Very difficult. In the meantime, let me take up with them as regards the circle officer is a party, na? Okay. We take it with them as to why they are not taking any steps as they have asked for. The dispute in the instant proceedings relate to as to whether the area where the petitioners are carrying on business falls within the Palimara Gao Panchayat or the Dhubri Municipal Corporation. Pustak. It is seen that the respondent, that the PNRD department, that the Chief Executive Officer Jila Parishad Dhubri have also requested the Circle Officer Dhubri Revenue Circle, who is the respondent number 7 in the instant proceedings, to submit a report on the location of the Dhubri Chaur Ghat and the Doinik Bazar. However, the respondent number 7 have not acted thereupon. In that regard, Ms. Enbora, appearing on behalf of the PNRD department, has placed the various communications which have been issued to the respondent number 7, but the respondent number 7 have not taken any steps. Considering the above, as Mr. K. Gogoi represents the respondent number 7, this court directs the respondent number 7 to submit the report as sought for by the communications issued by the Chief Executive Officer Jila Parishad. To direct the respondent, the circle officer, Dhubri Revenue Circle, to revert to the Chief Executive Officer Jila Parishad Dhubri thereby clarify the exact jurisdictional location of Dhubri Chaur, Ghat and Doinik Bazar, and whether the said area falls under Gauripur Anchalik Panchayat or Dhubri Municipal Corporation. Pustak. List this matter again on 9/1/2026 for an update. The instructions so placed by Ms. Enbora, appearing on behalf of the PNRD department, are collectively copied on record and marked with the letter X. Madam, in the meantime, what do you have to say? You have something? Huh?
For admission at 2 p.m.
Well, 2 affidavits have been filed.
So from 1/4/2020,
My lord.
who is holding it? Who is going to pay?
It is the, my lord, Home Department through the SP. Through the SP, my lord. DC's part will be, my lord, from 26/8/19 to 31/3/2020. They are processing, my lord, and regarding vacating the building, my lord, they say, my lord, they are seeing for 2 months' time, my lord, to have a different location. That is outer limit, of course, my lord. Some,
Let's have it after 2 months.
yes, my lord.
Give them time.
In the meantime, my lord, petitioner will cooperate. and, my
28th
lord,
of February
Lordship.
to vacate. And then we let us have it in the month of March, 9th of March.
Lordship. In the meantime, my lord, any bills are required to be submitted by the petitioner if to cooperate.
Bills, you know it, you unilaterally fix a rate.
Lordship will reflect in the
Now-
order so that I can communicate.
No, do I need to do it? The rate was 3 lakhs or something.
My lord.
You unilaterally say that we have made it 1,28,000. We are not going to say anything on that. But the fact remains that this amount you have to pay till 28th February 2025.
Yes.
So we are having it on 9th of March so that the entire dues are being paid at your rate, but giving liberty to file to the petitioner to file suit for recovery, thereby enlarging the period of limitation.
But they should package the.
Oh,
That is 28th February.
that goes without saying.
But-
I'm only first looking into it when they are vacating.
No, my lord, there is a letter communicated to the petitioner, my lord, in the affidavit filed by respondent number 7.
Regarding,
Regarding, my lord, that bills, my lord, DC has sought for a bill from the petitioner so that he can move the proposal, my lord, not
No.
for any other purpose.
petitioner would not
Not
submit
at
bill
least-
at 128.
No, I understand, my lord, that may be recorded, my lord, and some my lord, observation. to
No,
that.
you have unilaterally
We'll have to
fixed
process
it.
it.
So therefore, you are to pay. The moment the petitioner, he loses his right to claim 2 lakhs.
Yes.
That may be recorded, my lord, as the submission. At least I will have to convey to them, my lord, to move ahead with the proposal, my lord, to make the.
Heard Mr. I. Alam, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned additional advocate general, who appears on behalf of the Home Department as well as the district administration, Kachar. Pustak. The admitted facts in the present proceedings is that with effect from 1/9/2019, the petitioner's building was taken on lease by the respondent authorities. Pustak. It is the claim of the petitioner that the rent was fixed at rupees 3 lakhs. How much?
3,08,000, that is in my, justification I have annexed, my lord.
Fixed at rupees 3 lakhs. Where is that?
Page my lord, 47, in my requisition, annexer 10. And annexer 11, my lord, that is the certificate from the electricity engineer.
At 3 lakhs.
8,940,
Where?
Page 48, man.
page 48.
Is a certificate of
At
the.
3 lakhs 8,940. Excluding taxes. This was also certified by the executive engineer PWD, as we've seen from Annexure 11 to the writ petition.
And my quoted rate, my lord, 4,55,000, that is that page, my lords. Starts from page 34.
It is seen from the various orders passed by this court that the respondent authorities were earlier agreeable with the rate as stipulated in Annexure 11 to the writ petition. Be it as it may, the respondent number 11, the respondent authorities on their own again revised the rental, the lease rate per month to rupees 1,22,848 per month. Lease rate at rupees 1,22,848 per month. The admitted facts further show that not a single penny had been paid to the petitioner since 1/9/2019. And the respondent authorities have continued to use and occupy the petitioner's building.
By paying the electricity bill.
This court had passed an order on 1/12/2025. The petitioner is not only aggrieved by the non-payment of the rent, but also is aggrieved by the continued occupation of the building against his wishes. Under such circumstances, this court passed an order on 1/12/2025 inquiring when the respondent authorities would vacate the premises of the petitioner. And it was also observed that the said should not be beyond 31/12/2025. When a matter was listed before this court on 12/12/2025, the learned additional Advocate General Assam submitted that some more time may be granted to the respondents to vacate the premises. In that regard, this court gave liberty to the respondents to file affidavits. In pursuance thereto, two affidavits have been filed. One by the respondent number 7 on 11/12/2025 on
Filed yesterday, my lord.
11/12, na?
No, it was filed yesterday.
Filed.
Filed on 15th.
One was filed by the respondent number 7 and the other by the respondent number 8. In the affidavit filed by the respondent number 7, who is the District Commissioner Kachar, it is mentioned that the District Commissioner Kachar shall make a payment of rupees 8,77,863, being the rent for the period from 26/8/2019 to 31/3/2020 at the rate of rupees 1,22,848. In that regard, this court finds it relevant to reproduce paragraph number 4 of the said affidavit filed by the respondent number 7. It is further seen that with effect from 1/4/2020, the building of the petitioner is under the possession of the Superintendent of Police Kachar. Who is the respondent number 8 to the present proceedings. The respondent number 8 has filed an affidavit stating inter alia that they would be vacating the premises of the petitioner within 2 months so that they could identify a suitable place to shift the paramilitary forces from the present occupied building of the petitioner. Paragraph number 4 of the said affidavit being relevant is reproduced hereunder. It is also very pertinent to mention that in the said affidavit at paragraph number 4, it is mentioned that due correspondence have been made with the Home and Political Department for allocation of the requisite funds for clearing the rents due to the petitioner. The said stand so taken by the respondent number 7 and 8 in the affidavits, and the relevant portions of which this court have quoted herein above, would be construed to be undertakings given by the respondent number 7 and 8, and any breach of such undertaking would amount, and such undertaking, and any breach of the said undertaking would be construed to be a violation to the orders passed by this court. Accordingly, list this matter on 9/3/2025. 26. Number 1. In the meantime, the following directions are passed. The respondent herein, more particularly the respondent number 8, is directed to hand over the possession of the building in question to the petitioner on or before 28/2/2026. Number 2, the respondents herein, more particularly the respondent number 7 and 8, are directed to take effective steps for release of the rents to the petitioner, rents due to the petitioner, as per their to the petitioner on or before the next date. Number 3, this court have not commented, have not decided anything as regards as to whether the unilateral fixation of the rent by the respondent authorities at this late stage is permissible or not, which shall be considered on the next date.
For time being, Mr. Gupta is court number 1 in Lex. For time being,
Huh?
Mr. Gupta is in court number 1 in Lex. So time being, for time being.
Who is there?
H.
Mr. Gupta.
H. Gupta, H. Gupta.
What is the case about? Oh, this blacklisting,
No.
isn't it? What is this case about?
Rejection of technical bill.
After some time he will come out. After some time. কিমান লাগিব Gupta? Continue চলি আছে নকৰা। কিমান লৈ সময় লাগিব তাত?
Who is appearing with the private respondent?
My lords, we appear for respondent number 11. We are the successful bidder. I believe the private respondent would be respondent number 4.
Hmm?
My lords, we appear for respondent number 11, the
Okay.
successful bidder in the matter. And to my understanding, the primary respondent would be respondent number 4.
Respondent number?
4.
Yeah,
That's my understanding. my lords.
They have filed affidavit.
Who?
That's one of four.
Who has been given? It has been given to respondent number 11.
11.
Please, my lords, we are for the successful bidder, my lords. We have already filed a counter through e-filing. Physical copy will be handing it over today.
We have not received.
After something,
Hmm?
after something he will come also. After something.
In case your lordship, my lord, permit, may I make some submissions
Yes.
with respect to the case? My learned friend, my lord, whenever he is available, he can come and argue the matter.
Yes.
Yes, your lordship may kindly see, the entire controversy starts with the issuance of the NIT, which I have placed on record as Annexure 6, page 56 of my petition. This, my lord, bids are invited, my lord, for construction of a steel bridge.
Hmm.
And your lordship can see, my lord, the estimated cost of the work is rupees 1977 lakhs. And my lord, most relevant clause is clause 11 at page 57. This is the bone of contention. Entire controversy, my lord, revolves around this clause
By
only.
the valid enlisted contractor with BRO, who have submitted standing security deposit and MSME registered firm as pursuance of the year, but it is required for other contractors to be attached with the technical bid for rupees 15 lakhs in the shape of receipt of return book issuance of then from a nationalized scheduled bank and having maturity validity period of 90 days more than the validity of this contract. Okay.
My lord, the petitioner, being an enlisted contractor, did not submit the EMD along with his bid. As a matter of fact, petitioner is both enlisted as well as a MSME registered registered firm as well. As a matter of fact, my lord, your lordship can again have a look at the same clause. With respect to MSME, only micro and small were to be exempted. But insofar as the enlisted contractors were concerned, everybody was exempted. They refer to my rule 170.
Please.
Pay your lordship may kindly see when they initially rejected my case first time, there were twice they have rejected. That your lordship will have at page, my lord, 197, annexure 9.
Yes.
That is very interesting. Your lordship can see, my lord, grounds on which I have been rejected.
What is your name?
My name is my SGF Infra.
Huh?
SGF Infra. Your lordship may kindly have a figure. Yes, it figures as serial number G.
Okay, SGF Infra, yes.
Yeah.
EMD exemption limitation is rupees 11 lakhs only as the firm enlisted with the BRO. In this tender, EMD is sought for remand. The firm had not submitted the additional security amount against EMD. Hence,
Yes. May I explain, your lordship?
Yes.
Their contention is that you are enlisted contractor, all right. But as an enlisted contractor, your security deposit is only to the tune of rupees 11 lakhs. So balance of the amount you had to deposit. Now I will again take your lordship to the clause in the NIT, whether enlisted contractor were required to deposit anything extra over and above about the if their security deposit were lesser than the what was required by the EMD. Your lordship can again have to the look at the NIT, which is at page 56.
Yes. Okay.
Clause 11 will be at page 57.
Hmm.
All illicit contractor, irrespective of their security deposit, as per my respectful submission, they were exempted. They were not supposed to deposit anything if their security was less than 15 lakhs.
Show me the second reason.
Second reason, Your Lordship may kindly see, when they rejected my case on this ground, I submitted a representation to them. Your Lordship may kindly have a look at what representation I had submitted to them. That is at page 203.
Yes.
At 203, I submit a representation to them. And I take two reasons in that. Number, I say that insofar as my security deposit is concerned, it was already there to the extent of 11 lakhs. And you had said that the enlisted firms are exempted from EMD, irrespective of the what security deposit. Secondly, that I am otherwise also registered as a MSME under the relevant category, and our relevant registration certificate was also given to them. Your Lordship, may I will here explain one thing.
Yes.
When I gave it to this communication to them, they respond me. Kindly have a look at, my lord, the next page, page 204.
Yes.
They say that since your registration is as MSME is this, my lord, medium, so only small and micro are entitled to the exemption.
In terms with 170.
In terms with 170. Then I bring to their notice that this classification has changed. Your Lordship can have a look at, my lord, my next communication, which is at page 207 and Excerpt 12.
Let's come to 206.
Yes, madam.
Page
This
170.
170. 206, my lord, it confines the benefit of, my lord, EMD in favor of MSME who are registered as small and micro. Medium is not entitled to the benefit. May I read, my lord? May I read, Your Lordship?
During the period if they awarded the where do we find out that?
Yes, madam. To safeguard against bidders withdrawing or altering its bid during the bid validity period in case of advertised or limited tender inquiry, the bid security, also known as earnest money, is to be obtained from the bidders except micro and small enterprises, as defined in the MSC procurement policy issued by the Department of Micro, Small and Medium Enterprises. So only micro and small were granted the exemption. Now question arose, what was my categorization? At the time when I initially registered, I was registered as a medium. Subsequently, the criteria has changed. Your Lordship may kindly have a look at my response to their this objection. Have a look to Your Lordship at page. This is Annexure 12, page 207.
So you are no longer medium.
I am.
You have
Yes.
become a micro or a small now.
I was a small. Your Lordship, may I will show my registration also. Your Lordship may have a look at page 194.
Yes.
19. I am micro with effect from 1st of April. I am small with effect from 1st of April 2025.
Okay.
Then Your Lordship may kindly see, when I brought these facts to their notice, then they issued me a communication. Your Lordship, I'll refer to that also. That Your Lordship may thinking. Have a look here, page 219 and Excerpt 13.
Yes.
Here they concede that yes, we have verified you have been registered showing as a small enterprise. May I read, my lord?
Please.
In this connection, it is
showing as a small enterprise.
small enterprise. They say then they demand from me these documents. Consequences, your annual update required. You must update your registration detail, including your latest income tax and GST filing information on the Udyam portal at the end of every financial year. The update process is done online on the official Udyam registration portal. Consequences of not updating, failure to update so and so, so and so. And then they say, what they demand from me at page 220. In view of the above, it is requested to submit proof of annual update details, latest income tax details duly signed by CA and GST filing information uploaded on Udyam portal for the financial year 2024-25 along with the supporting docs uploaded so and so, so and so, so and so. So what they are demanding from me is that, my lord, my income tax return and GST filing returns for the year 2024-25.
Okay.
This is the before the date of the NIT. Now kindly see whether this information is at all relevant for my enlistment as a micro enterprise. Your lordship may kindly have a look at. I explained to them.
But
Next.
one thing, Mr. Pant, kindly have a look at the notice inviting tender. The
Yes,
last date is on 16th of July 2025.
Yes, your lordship. Yes, my lord.
And if I see at page 194,
Yes, my lord.
this document is printed on 24/4/2025.
This is the print which we have taken from the site.
No, understood.
Yes, my lord.
So on 24/4/2025,
Yes, my lord.
it is already updated.
It is updated. For the reason, I will explain what is the reason. The reason is that now you don't have to manually do anything. Your this registration is linked with your GST portal and income tax portal. Everything you do, it is auto fetched. And thereafter, you don't have to apply for renewal or change in your this nomenclature. Everything is done automatically. That is explained by the department. Kindly have a look at the explanation, which is given by the department.
Page?
Page, I'll explain. My notes. Enough. Your lordship may have a look at page 226. Rather 230, your lordship, clarification.
Mr. Pant, just excuse this court for some time. There is
Yes.
one matter which I need to finish it off.
Yes,
It
your
won't take them more than 10 minutes.
Yes, yes.
We'll
Your
just finish up that, then I'll take up your matter.
Yes, your yes.
Mr. Dasgupta, that's for you. I need to release you as soon as possible.
29.
You filed the affidavit, individual affidavits?
Their affidavit is marked as A, ours is marked as B.
So the total here is at page 40, running page 40.
Yes.
The total amount to be paid is 64 lakhs 34,
Yes. That is
64.34 lakhs.
that they have agreed, your lordship.
Huh?
That
You have agreed. Okay. So the amount is retrenchment is 14.65 plus gratuity is so and so plus 41 lakhs.
yes.
This is your they heard there. And what is your stand?
Ours, your lordship. Ours also same, they have accepted that. The one issue is that, your lordship,
Hmm.
we have suggested that we'll pay the first installment 50% now after your lordship's order and rest of the 50% after 2 months.
No problem.
Yes.
You'll get it You'll get paid by 14th of April. 14th.
Yes, and we'll try to pay before that. Only thing is that once we pay the last installment, they should simultaneously vacate the quarters. That is our prayer. They have in their affidavit, they have said they will need at least 1 year after getting the payment. That is, your lordship,
6 months.
6 months.
6 months. We give you 6 months.
Time I leave it to your lordship.
6 months. You do one thing because you see, they need some money. It will be taken as an undertaking that they vacate within 6 months. We give the date on or before so and so they will be vacating. And as regards the payment, you pay immediately within 20 days, 15 days, first installment, and the second on or before 14th April. And you vacate by, today is 22nd, 19th, 17th, you vacate it. By 30th of May, 30th of May 2026, you vacate. I hope. Heard Mr. A. Dasgupta, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioners. And Mr. R. Sharma, the learned counsel, who appears on behalf of the respondent. Respondent number 1. One, na?
One respondent.
They have made only one. They didn't make others. Otherwise, I would have been able to a bit more flexible. I could have flexed something. Very difficult. Huh?
This is an award.
Maybe, but then also, because you see, normally what happens when you challenge the award, you also make the government a party, taking into account the government issues the notification, notifying the award. But anyways, although it's not necessary, but it would have helped me a bit. Anyway. The instant proceedings have been filed by, the instant proceeding is filed by the trade union against the respondent, challenging the award dated 30/11/2013 passed by the Learned Labour Code, Guwahati, Assam, whereby the reference was decided against the workmen. During the course of hearing on
Pipeline 2024.
on 28/10/2025, this court, upon hearing the parties, inquired as to whether there is any possibility of an amicable settlement, and in that regard permitted the petitioner and the respondent to submit a proposal without prejudice. In pursuance thereto, various proposals have been exchanged between the petitioner and the respondent. On 20/11/2025, the Learned Counsel, who represented the petitioner, had submitted that the petitioners were agreeable for an ex gratia payment of rupees 41 lakhs plus rupees 23 lakhs 23.34 lakhs towards gratuity and retrenchment benefit. To the said, a proposal the Mr. Ashama had also submitted that the respondent was also agreeable, subject to vacation of the quarters by the workmen. Accordingly, this court therefore directed both the parties to file affidavits before this court. In pursuance thereto, both the petitioner as well as the respondent have filed affidavits. In the additional affidavit filed by the petitioner on, what is the date of filing?
I have filed on 8/12/25.
No, what is their filing date? Have you filed?
Same
it? No.
8/12/25.
Have you, how, এখন কেনেকৈ হৈছে চাওক এইবিলাক কোনো সিল নাথাকে নেকি আজিকালি ফাইল কৰিলে সিল নাথাকে নেকি কোন কেনেকৈ ফাইল হয় মাৰকচোন নোটাৰী কৰিলে নহ'ব নহয় সিল হাইকোৰ্টে সিল নাথাকে নেকি কোনে মাৰিব মই মাৰিম নেকি মাৰক In the affidavit, additional affidavit filed by the petitioner, they have indicated the amount of gratuity payable by the management and enclosed the table as Annexure A. From a perusal of the said annexure encloses as A to the additional affidavit, it is seen that the total gratuity payable has been claimed at rupees 14 lakhs 64,716, or roughly 14 lakhs 65,000. Has been shown as rupees 8 lakhs 69,502. And the retrenchment benefit have also been shown as rupees 14 lakhs 64,716, roughly rupees 14 lakhs 65,000. It is also being stated in the additional affidavit filed by on behalf of the petitioner that they are agreeable for an ex gratia payment of rupees 41 lakhs Pusto. Thereby, the total claim of the petitioner is rupees 64.34 lakhs. It is also mentioned that the members of the petitioner would vacate the possession of the quarters within 9-12 months' time. Further to that, it is also mentioned that the said amount of rupees 64.34 lakhs be paid into the account of the Billworth Shramik Union, Central Bank of India, AC number 151855741-2, bracket 3203, Dispur branch. Gusto. Paragraph number 5, 6, and 7 of the said additional affidavit being relevant is reproduced herein under. The respondent has also filed an affidavit on 15th of December 2025. Wherein they have also agreed to the said amount of rupees 64 lakhs 34,000 as at full and final settlement. And it is further stated at paragraph number 7A of the said affidavit that the 50% of the amount will be paid within 30 days from the date of the court's order, and the balance 50% within 60 days. It is also mentioned that on the payment of the final installment, the workman should simultaneously the workman would simultaneously be required to vacate the respondent company's quarter located in the premises of the respondent company's property, which is still in their occupation. Paragraph number 4 to 7A being relevant is reproduced herein under. This court have duly heard the learned counsels appearing on behalf of the parties. And from the affidavits so filed before this court, it is apparent that both the parties have agreed to a full and final settlement. And the figure has also been arrived at. The figure have also and the figure and the amount of rupees 64 lakhs 34,000 have been agreed to as the full and final settlement. Issues have arisen. There have been certain differences as regards when the entire payment would be made and when the workman would vacate the quarters. This court sought for instructions asked the counsels representing the petitioner as well as the respondent to obtain further instructions in that regard. And they duly submitted that the petitioner herein, the members of the petitioner union, would be willing to vacate their quarters on or before 30/5/2026. Mr. R. Sharma, appearing on behalf of the respondent, also submitted that the first installment, that the 50% of the amount shall be deposited in the said bank account.
Your Lordship, there's one issue. In paragraph 7 of the affidavit, they had said either release it to the members or to the union account. We have been always paying by check to the workers. So that procedure may be accepted. We'll pay by check, we'll file a compliance affidavit. We may file a compliance affidavit also if required. We'll pay check by check to the individual workman, not to the union account. That might create something. If
That is up to your lordship. It is up to your lordship. It will be better if the union disburses the same. Or if you have the
there may be
contact,
some dispute
or
again,
then
your Lordship.
I don't have it.
You will pay by check to, because in
the contact all the.
para 7, they said either to the workman or to the union account. Your Lordship will pay directly to the workers.
Why I said so? You see, there's a problem out here. There will be some persons, if you see the affidavit, why I'm saying so. These are 48 people, 41 persons. Out of this, some persons have received something
Yes.
and some have not received. Would they be agree? You are agreeing on this aspect, Annexure A? You have agreed because you have also enclosed
Yes.
that. Okay, so then I direct them to make the 50% payment on or before uh, on or before, pay the first one before Bihu, 9th. No, our Bihu is 9th, not them, by 12th. First installment. Okay. Mr. R. Sharma, the learned counsel appearing on behalf of the respondent on instruction submits that 50% of the amount shall be paid to the workmen individually on or before 12th of January 2026. As regards the remaining amount, the same shall also be paid individually to each of the workmen as per their entitlement, taking into account Annexure A to the affidavit filed by the additional affidavit filed by the workman, by the petitioner.
Sir, even below the compliance report has to be submitted.
No, don't worry. This is his submission. Let me complete it. On or before 13th of April 2026. Taking into account the above submissions, this court therefore disposes of the instant writ petition with the following observations and directions. The petitioner herein, the respondent herein, both the petitioner as well as the respondent have agreed to an amicable settlement of all their disputes. Whereby the petitioner herein, the respondent herein shall pay a total sum of rupees 64 lakhs 34,000 in total to all the 41 members of the petitioner union. By taking into account Annexure A to the affidavit, additional affidavit filed by the to the work members of the petitioners union. The entitlement against each workman, each member of the petitioners union shall be calculated on the basis of Annexure A insofar as retrenchment and the gratuity. And as regards the ex gratia payment, each of the 41 workmen, member of the petitioners union, would be entitled to an equal amount, that is rupees 1 lakh each. Number two, 50% of the said amount of rupees 64 lakhs 34,000 shall be paid shall be disbursed by the respondent to the members of the petitioners union individually on or before 12th of January 2026. Number 2. The remaining amount of rupees, shall be disbursed to the members of the petitioners union on or before 13th of April 2026. First. Number 4. A compliance affidavit in that regard be filed before this court on or before 8th of June 2026. The members of the petitioner union who are presently in occupation of the premises of the quarters in the respondent's establishment shall vacate on or before 31/5/2026, and a compliance affidavit would be filed on or before so and so. I got it. It is observed that if the compliance affidavits are not filed as directed herein above, the registry shall put up the matter again before this court. Well, at last, it ended.
Oblige, your lordship.
No, I saw you, Mr. Dasgupta. I don't want to further if you send it out here.
No.
Just Mr. Dasgupta, just. এখন ফাইল হৈছে ইয়াত লাগি আছে how is it possible এখনত ইফিনো সিল টিল নাই যে সাফ নিয়ে ফাইল সিল নাই সব কেতিয়া ফাইল কৰিছে তুমি একো নাই না ফাইলটো কৰিছে তো ডেটটো কেতিয়া আছে ফাইলটো when did you file it, Miss Das?
8/12.
8/12.
This you filed it on 8/12.
Same.
Why will you put a date also? Put your date out here, 8/12, and they will put regular school report. And you can record it here, so record it will be easy. You can read to the answer. So here is what I need to do.
নহ'লে কেতিয়াবা কি আগতে মই এটা 21ৰ ইনচিডেণ্ট পাইছোঁ ভাই পোষ্টত আহিছিলে তাত চিৰিয়েল একো নাই সেইটো আমি ভেৰিফাই কৰি ডেছপাছত গম পালোঁ যে সেইটো বাই
Did you file this affidavit in the registry? This affidavit, the additional affidavit? But how, why there is no seal?
File by the advocate clerk.
Huh?
File by the
Copy has also been given. চাবচোন কেনেকৈ ৰেগুলাৰাইজ কৰি দিব
ঠিক আছে
কিন্তু মই এইখনৰ বিশেষ অৰ্ডাৰ দিলোঁ দেই you need to comply with it. You just go there and once you put the signature out there, well, the signature is missing out there of yours. When the signature is there, but your date is not there. The date has to be mentioned and they will put the seal out there because this needs to be regularized. Otherwise, it will as if it is not there. The bench section have duly taken acknowledged this filing, but the filing section have not. Okay.
Oblige.
Yes, Mr. Pant.
Yes,
Sorry.
yes, Your Lordship. Your Lordship, my Lord, I had referred to the communication by the respondents, whereby they initially rejected my case. Thereafter, I submitted to them my representation. They reconsidered the matter, and they came forward that you are listed as a this, my Lord, medium enterprise. You are not entitled to this benefit. Thereafter, again, I wrote to them, and thereafter they demanded from me some information. Your Lordship can have that information at page 219. Wherein
I've looked
they
into it.
admitted that I am small, but they said provide me this information. They wanted to have from me income tax return and my lord this GST return uploaded on the Udyam registration portal for the financial year. That is very important. 2024-25.
How can you submit?
Not possible. And number two, not relevant. Why? Have a look at, sir. Have a look at my reply to them at page 221. I explained to them that two things, that this data is auto fetched by the portal. Number two, for my enlistment for the year 2025-26, you are demanding from me 24-25, which is not at all relevant. Now kindly see what is relevant. Have a look at the clarification issued by the ministry itself, page 230, sir. 230.
Yes.
Your Lordship can see, my Lord, the first of all, this para third. Further, it is added that data of investment and turnover either get autofilled or slash fetched from the income tax department and GSTN for those enterprises who have filed IT and GST returns, or is filed on a self-declaration basis by those enterprises who are yet to file the IT and GST returns. The data which gets autofilled fetched from the IT department and GSTN is the data which had been finalized by the above respective department after rectification, wherever necessary for the relevant
No, Mr.
financial
Pant,
year.
I've understood. You see, for 2024-25,
25-26.
no, 2024-25,
Yes, my
you
lord.
are to file your IT returns, taking into account that you come under the audit.
Yes, ma'am.
Even I think now 15th of December was the last date.
This year they had extended, otherwise it used to be 30th of October.
Yes, no, that understood. But this
Yes.
time they have.
This
We are
time they
concerned
have.
with 2024-25.
Yes, my
Yeah,
lord.
in this petition.
Yes, my lord.
So in 2025,
No, my argument is slightly different. I say 2024-25 is not even relevant. Have a look at the last para of this clarification. For the financial year 2020-21, what is relevant is 2018 and 19.
No, that I have understood. Mr. Pant, I hope you understand. I have understood your point. Don't need
Yes.
to emphasize that. So that is why I'm saying you cannot be asked to submit a 2024-25, taking
Yes.
into account your last date is on 15th of December
15.
this year.
Yes, your
So
lordship.
therefore, the question does not arise. That too, when your certificate, which is there,
Yes, my lord.
categorically mentions it to be a small enterprise.
Small
And that is
enterprise.
why I say it has been printed, taken out and printed on 24/4/2025.
Yes, my lord.
That is pursuant to the amendment,
Amendment. Yes, your lordship.
whereby the circular was changed, the
Criteria.
the value of the MSMEs have been changed.
Yes, your lordship.
And thereupon you have now come up, so therefore that particular document is the main document.
Main
Do they have to ask for other documents? How they can ask for other documents?
They were not
Which is not
required.
the mandate of the tender condition.
Yes, your lordship. Yes. And
Your
I will,
therefore
my
submission,
lord.
Mr. Pant, is this. Clause 11 says that you are required to, if you are registered with the BRO and an MSME, then you are entitled to the exemption of the earnest money deposit.
Yes, ma'am.
They first rejected you, saying that you were registered with the BRO, but while being rejected with the registered with the BRO, you had only 11 lakhs, not the 15 lakhs.
Yes, ma'am.
Then you made it clear by filing a representation Then they came up that you don't come in because you are a medium enterprise on that date.
Yes, Your Lord.
Then you submitted that in view of this circular which has been issued, the amendment which has happened to the MSME Act, so thereby the figure having been changed now to be a medium, it has to be 250 crores, and below that comes on the small.
Yes.
Now, as on 24/4/2025, you were put in the Udayam certificate, which is done in terms with rule section 8.2, that you are a small enterprise.
Yes, ma'am. Yes.
Now,
Absolutely.
instead of going into all these things, they are now asking you to provide the GST and all these things,
Yes,
which is
ma'am.
automatically fetched.
Yes, madam.
Be that as it may, you cannot go and ask for 2024 and 25, taking into account that last period is on 15th of December.
Yes, madam.
So that you, at best, you could have asked for 2022, 23 or 24, 23, 24.
Yes.
Not for 24, 25.
Absolutely.
So that's your case.
Yes. I will, my lord, I'll clarify a little bit. Your lordship may kindly refer to clause 11 at page 57.
Yes.
Two kinds of entities. It is not, my lord, and has been viewed. It is to be read disjunctively. Your lordship may kindly see.
Mr. Pant,
Yes, ma'am.
I hope I have understood.
Absolutely fine, sir. Absolutely fine.
I think you have said your case. Let's hear the other side.
I will only clarify by additional affidavit that prior to this bidding process, I had participated in 3 different bidding processes by the same organization where my earnest money deposit was my security deposit less than the EMD which they were demanding from me. But despite that, since I was an enlisted contractor, maybe with the less security deposit, they held me eligible, awarded me the contracts also.
So,
And
what?
at that point of
So,
time,
Mr. Pant, what principles should I follow then? And legally
that
speaking, what
anybody who's
principle
an
would be that?
enlisted contractor, anybody who's an enlisted contractor was not required to give any security deposit, EMD.
No, that is apparent from
Yes.
clause 11.
Yes,
So
ma'am.
whether they do it or not, whether they do not do it, that is immaterial.
Yes, ma'am.
Do you gain out here on the basis of a reading of clause 11 as it is?
Yes,
I'm
Your
going
Lordship.
to only read as per clause 11.
Yes.
The railways having done earlier or they have not done out there, I don't think that would be a material consideration for the purpose of deciding. Let's hear the railways first.
Yes, sir.
Mr. Gupta.
Initially, my lord, the rejection was made on the ground of violation of clause 11, my lord, wherein that
You said that it is
15
there is
lakhs
a
was-
requirement of 15 lakhs, so but he had 11.
yes. Now, my lord, subsequently to overcome that, my lord, they have produced thereafter the MSME certificate. Whereas, my lord, when at the time when the bid was submitted, my lord, at paragraph 45 of our affidavit in opposition, we have stated, my lord, when at the time when the bid was submitted, my lord, that certificate was not enclosed by them, by which they are seeking the exemption. And
Where is that records?
my lord,
I therefore ask for the records. Is that the small, the record is so small, or maybe the contract is too small, I suppose? Only 19 crores. Okay.
if my lord takes the page 30, my lord,
Page?
page 30. Page 30 is the certificate, my lord, which they have uploaded. If my lord takes page 31, in the type of enterprise, my lord, it is categorically mentioned, my lord, type of enterprise as medium enterprise, my
So
lord.
they included this one.
Yes, subsequently, my lord. Initially, they have not. Initially, they have not enclosed, my lord.
Are you saying that they have given this one, not the other one, which is they have enclosed with the petition?
My lord, they have given this one, my lord, which I have just now given, my lord, the page 30 and 31. because we have stated in the affidavit, my lord, that no updated Udyam certificate classifying the petitioner as small enterprise was uploaded at the time of the bid submission. No request letter invoking MSME exemption was submitted either. When the bid was submitted, my lord, the exemption which they now are claiming, my lord, that was not submitted.
Mr. Pant,
initially.
Yes, your
you
lordship.
did not submit this certificate which is enclosed to the petition?
No, your lordship may kindly see, your lordship may have a look at, my lord, what they have clarified here. Annexure 11, page 204. This is dated 22nd of September 2025.
Yes.
Your lordship may kindly see what the para 3, as per rules 171 of GSR, bid security, also known as earnest money, is to be obtained from the bidders except micro and small enterprises as defined in MSE procurement policy issued by the Department of Micro, Small and Medium Enterprises. MSF copy enclosed. The uploaded MSME certificate of your firm is a medium enterprise, hence exemption EMD is not applicable. This is what they conveyed to me. Then kindly see, sir. I had
No, Mr. Pant.
Yes.
My question is, did you
Yes.
enclose this certificate of 24/4/2025?
Initially, it had not been enclosed.
Then your case is bad. Okay, that is it. We don't need anything more. Why you are enclosing? You should have come up very clearly out there. Did you issued that certificate? My question is, therefore.
No. Subsequently,
enclosed
your
out
lordship may
here? No,
kindly
Mr. Pant,
subsequently.
sorry.
Then your lordship.
Bench will help you. Why on earth have you enclosed this page 194?
190.
This is a certificate which was very much available to you on 24/4/2025.
Absolutely, sir. Absolutely,
You
it
had
was
taken
available
it.
to me. Your lordship may kindly. Your lordship may kindly. No. On different aspect of the matter. I am.
No. Enough. We have heard you.
Your lordship, my lord. In case your
No.
lordship give me 2 minutes.
Heard, Mr. No, enough. Hello. Heard Mr. R. Pant, the learned senior counsel, assisted by Mr. K. Kwalite, appearing on behalf of the petitioner. Mr. H. Gupta, the learned standing counsel, learned central government standing counsel, appears on behalf of the respondent numbers 1 to
10, my lord.
1 to 10. 1 to 10. You are appearing. What? Who is P. Gupta? I don't know anybody. No, I have not heard her. Anyways, none appears for respondent number 11. when a matter is taken up.
respond number 11 minutes.
The petitioner herein have approached this court.
Minutes, I appear for respond number 11 minutes. Am I audible?
What?
We had submitted in the morning. I appeared for respond number 11 minutes. My senior appeared minutes. We had filed our counter. We had made the submissions in the morning minutes.
You made the submission before whom?
Minutes, you only. It was just minutes the matter when it was heard earlier. My senior appeared minutes for respond number 11 minutes.
Did you?
Please, minutes. My senior
When?
was there. Minutes just
When?
now when the matter was taken up and then Millards heard another matter. Minutes
Chalo.
before. Please, minutes, yes. It is Tanupriya Gupta Millards. I appear on her behalf.
No. What is your submission?
Millards,
Make
we
your
had filed.
submission.
Millards, we had filed a reply.
Okay,
Millards.
you
We are-
make your submission. What is your case?
Millards, no, we were just trying to say we had filed a
What
reply.
is your
Millards.
submission, madam?
Millards, then in that case, Millards may give me a very short pass over. My counsel is in another matter. Millards, urgent matter. Millards, we are the
pass a stay
successful.
order.
No, we are successful.
No,
because
we pass a stay order. Heard Mr. So-and-so. Mr. Gupta, we pass a stay order. We'll see later on. Okay.
My lord will dispose of, my lord, since this project is of national importance, my lord, we have.
17 crores is national importance.
No, my lord, it's Arunachal border. my
Two
lord.
peanuts. It's peanuts.
My lord.
Very small.
My lord.
When we are concerned about 3,000 crores, we are not concerned with the 17 crores. It's too small a project.
The
state.
construction work in the border of Arunachal and.
We have to
China.
give an opportunity to respondent number 11 to also submit.
The whole ready respond number 11.
The respondent number 11 has not come up.
Millards, we are here, Millards. Give me a second, please. I'm very sorry.
And you are not going to submit. You don't know.
That's one.
What is your submission? What is your submission?
My lords, for respondent number 11,
Yes, what is your submission?
please, my lords.
What is your submission?
Please, my lords.
Yes?
My lords, I'm so sorry, my lords, just 1 second. My lords,
You're
My
not
lords,
ready?
No, my lords, is
Don't
it
go
possible?
ahead with the work. We state.
My lords, we are, no, my lords, I'm making my submission.
You're not ready.
My lords, I am in fact, my lords, I logged in at 2 o'clock. There was another arbitration at 3. I thought, I was told that it will be taken up at 2 o'clock. I'm so sorry for this confusion, my lords. My lords, in this case, if my lords may see, the season which is at page number 200.
Yes.
Well, as it has already been brought to the notice of this honorable court that there was a rejection, and the rejection was because the EMD entire amount was not deposited. So let me, my lords, put this into perspective. That what only the enlisted contractor are entitled to exemption. So when I say enlisted contractor, my lords, this particular contractor was S-class contractor. So there was this upper tender limit. My lords, in that case, it is 1,500 lakh rupees work. Whereas the work which is the subject matter of this case is 1,990 lakh. So therefore, my lords, firstly,
Well, which is the term of the contract which states so? The notice inviting tender says so.
please, my lords.
Which is the term of the notice inviting tender say?
My lords, I'll
Because
come
clause
to that.
11 does not say anything
My lords, I'll
except
come to
it
that. My
only
lords.
says about the requirements. One, that he is a person concerned is an enlisted with bro, and second, that he is a MSME.
Malas, I'll come to that. Malas may again come to clause 11. I know it has been read again. So I'll be making it again. Kushi, can you log into that arbitration? Let me read Malas 11A.
11?
A. Earnest
11.
money. Yeah, earnest
Yes.
money. Please, Malas.
11, yes.
Malas, it says earnest money is not required to be attached with tender by the valid enlisted contractor with BRO, who have submitted standing security deposit and MSME registered firms as per 171 of GFR. Let me again emphasize on the fact it says valid enlisted contractor. Malas, in this particular case, this enlisted contractor is the S-class contractor, wherein he has deposited rupees 11.
So you are trying to say that the railways have adopted a hidden criteria
No, Malas, there is
in
no
the
hidden.
name of valid enlisted contractor.
Malas, the understanding of valid enlisted contractor in this case, Malas, this is S-class contractor.
Where do you say from? My only question is, where do you say that a valid enlisted contractor is some S-class or Y-class contractor?
Malas, because that is the criteria, Malas, because they are enlisted in BRO. Malas, if they are taking exemption.
No, but madam, you see, I am not a person who is employed out there in the BRO. You are to place it before this court that to be a valid enlisted contractor, you have to be X, Y, Z class of out there, and it is only X or Y who can participate. Where is it mentioned in the tender condition?
Malas, in fact, if I can be just given.
So you therefore say that they have applied a hidden criteria.
Malas, there is no hidden
On
criteria.
your ground only we admit
Malas,
it.
give me 2 minutes. Let me make my submission.
Yes, tell me.
It's just that I thought that respondent number counsel for the respondent number 4 is going to lead the matter, and I'm not sure that why that hasn't happened.
Respond number 4. Respond number 1 to 10, they have already made the submission. You were not there to be found. You
Malas,
made the submission. Why you are
said-
saying that to be a valid? What is there any definition of a valid enlisted contractor in the contract terms?
Right. Malas,
Where?
let me explain this, Malas, to My lords, as far as the varied enlisted contractor is concerned, the very concept is there are certain classes. Now, this particular contractor belongs to class S.
So
Now,
he
for-
cannot participate.
No, my lords. For class S, there is upper tendering limit, which is at max is 1500 lakhs. Whereas in this case, my lords, the work order was for rupees 191,990 lakhs. Now for 1500 lakhs, the standing deposit is rupees 11 lakh. And then there is another class, which is SS class. Now for that, there is no upper tendering limit. And the security deposit is 15 lakh. Now, my lord, this very material fact, for some reason, has not been argued or touched upon. So once you are the BRO enlisted contractor, it's a part of your enlisting conditions. And since they are seeking this exemption, they are very well aware of this.
So, madam, the thing is, there is no definition of valid enlisted contractor.
My lords, besides that,
Huh?
my lords, besides that, if I come to B, let me also go through the entire clause 11.
Yes.
Earnest money 11A only talks about valid enlisted contractor. Now, this honorable court's query is that where is the definition? Now, my lords, if we see the holistic approach, the way this entire clause is framed in NIT, B says unlisted contractor and enlisted contractor with VRO who have not submitted standing security deposit will submit the tender accompanied with the earnest money deposit of rupees 15 lakh. So even the unlisted contractor who have not deposited the security money, even they are liable to make the submission of rupees 15 lakh. Now, in this case, this particular contractor who is under S class, he has only deposited the security deposit of rupees 11 lakh. Now, there's a remaining of 4 lakh rupees, which he hasn't done. Otherwise, my lords, if that is the case, the way this query is being framed and what I understand, there was no need for the clause B to follow in such a case that even the enlisted contractor who hasn't deposited the standing security, even he would have been exempted completely. But that is not the case.
So you therefore say from 11B,
if I read
even an enlisted contractor of the BRO is also required.
Right, where there is no security
to
deposit.
submit.
Right. Because the
But
security.
but what do you say? An enlisted contractor but an MSME.
Now, as far as MSME is concerned, my lords, because I'll come to the decision.
No. You see, clause 11 of the notice inviting tender as well as clause 11A and B. The difference is there.
Right.
If a BRO enlisted contractor is an MSME, is a different thing. Whereas, and there might be an enlisted contractor or there might be an MSME. But if a BRO enlisted contractor is not an MSME, the question of granting a benefit under for exemption of the EMD does not arise.
Right.
And taking into account the GFR 170 rule 171 of the GFR, it says that it is only given to the micro and small.
Very well. Please,
So
panels.
therefore, what appears from 11A or reading at page 56 is that he has to be an enlisted contractor.
Right.
One. Secondly, he has to be an MSME, of which he has to be a micro or a small.
Right.
Then he gets an exemption.
Right.
But if he's just an MSME or an MSME which is medium, would not get the benefit.
Please, my lords.
If he is enlisted also, he won't get the benefit. But he has to have the combination of both, that is enlisted and small or a
Right.
micro.
Right. And in that scenario.
But they don't come up with that issue as regards the valid enlisted contractor.
My
That
lords,
will be a hidden criteria.
My lords, let me answer it one by one. Let me come to the MSME part now. My lords has already framed it rightly. My lords, it's only in a case wherein it is micro and small who is entitled to exemption and not medium. Now, my lords, let me also just read this one, the response to their representation. Now, what has happened in this case? The certificate which was uploaded at the time of bidding reflected medium. And these are the only documents which an evaluation committee or board in this case could have considered.
Mr. Gupta, just tell me one thing. Like we have a Procurement Act of 2017. You also have a procurement order.
Yes, ma'am. Yes.
What does it say as regards this certificate, which is of historical significance?
But here, my lord, the certificate itself was not uploaded.
Huh?
When the bid was submitted. my
No, no,
lord,
no. That is
that
okay.
the
That
bid-
is okay. But I'm asking you, what about a historical document? How do you take care of it? Because you have an order of 2017. I think now it has become an act or something.
Yes,
Because that day I was looking into the CSIR. They also have, they follow the GFR as well as they also have a procurement order. What does it say about the procurement order?
I have to verify.
Yes, yes. Act.
My lord.
Now, what do you say about this? Is after all, it is there as on 24/4/2025. Yes, the petitioner did not do it. That's another thing. But if the act or the order permits so, taking into account that it is a historical document, so because the last date of submission was on a particular date,
My lord.
and if that is the last date is submission is that date, because you see, if I remember correctly, in respect to other matters pertaining to the Assam Procurement Act, which is also worded, it didn't make a new act on its own, so they have imported from the central government. There is a saying that these are historical documents, like the MSME certificate would be a historical document. It is not there that they need not have it. Like an annual turnover certificate by a CA may not be a historical document, but the audited balance sheets would be a historical document. So the MSME certificate was very much there on 24/4/2025. How do you take care of that situation?
It should have been uploaded, my lord. How the authorities would come to know, my lord, that they are claiming exemption under that particular category. Our categorical stand in paragraph 45 of our affidavit is this, my lord, that they have not uploaded such certificate with the bid. The question of consideration would arise, my lord, once.
No, there's no quarrel with that. How will you know is very much known. There's no quarrel with that. You just put that number out there, you will get it no. But can you take into account this certificate given at a later point of time? That is my question. Although this is not the argument of the council appearing on behalf of the petitioner, but this is my question as to can you take it subsequently?
No.
Whether that act or the order permits so, that needs to be seen. Mr. Pant, I think you need to look into this aspect. Otherwise, you don't have a case. And you have become mute.
In fact, my lords, if I may add, that was a particular stance which was
May I, my
taken.
lord? May I clarify, your lordship?
Yes.
First of all, my lord, your lordship's query that one has to qualify both things. It has to be enlisted contractor and MSME, both, to claim the benefit. I think, my lord, my learned friend, the respondent from number 4 will clarify before your lordship that it has to be either of the two. Either, your lordship, I'll read it again for the convenience of the honorable court. Earnest money is not required to be attached. This is, I'm reading, my lord, clause 11 at page 57.
Page 72, read it.
Page 72, your lordship. Yes, madam. Earnest money is not required to be attached with the tender by valid enlisted contractor with BRO who have submitted standing security deposit and MSME registered firms. There are two, my lord, used disjunctively. Either you are a enlisted contractor or you are a MSME. The initial, my lord, my rejection was not on the ground that I am not MSME. Initial rejection was on the ground that you are a listed contractor, but your security deposit is only to the tune of rupees 11 lakhs. And you have, you are
Mr.
short.
Pant, kindly see, Mr. Pant, see the next one.
Yes.
The
Yes.
next 11B.
11B. Unlisted contractors and enlisted contractors with BRO who have not submitted
So
standing
therefore, an
cure.
enlisted contractor with a bro also
Yes, my
is
lord.
required to submit a 15
Yes, yes, absolute. No, no.
So
not
therefore,
15.
if you are saying this to be or, not end, then in that regard, it goes against this 11B.
I'll clarify. There can be enlisted contractors who have deposited the
And
security.
Mr. Pant, also you have to understand FCONs. The
Yes.
Supreme Court says that it is for them to understand better.
No,
We
no.
don't
Once,
understand,
my
and
lord.
we have to defer our judgment to what they understand. And Mr. Gupta is the best person to understand now.
Yes. If Mr. Gupta says, my lord, I have to meet both the requirements, then my lord, your lordship will be, my lord, well within the rights of the honorable court
Mr.
to
Pant,
say
you
it
need
so.
to look into the other angle.
I'm on that also. I'll come to that also. In case your lordship only permit me 2 minutes, I'll explain
No,
everything.
not on this. This I have made up my mind. You come to that.
That also, your
Whether
lordship.
a historical document,
Yes, ma'am.
because your document came into existence immediately upon the amendment made to the MSME Act.
Yes, your lord.
So you automatically became small. And your last date of submission was sometime in the month of August, July or August
July.
2025. July. So therefore, as on 24/4/2025, as
Yes,
it
ma'am.
could be seen from your document itself, you
Yes,
had that.
Yes, ma'am.
You carelessly have not placed it. You should
I'll
have given
explain.
that, but you
Yes.
have carelessly not placed it. You have given the medium enterprise thing.
Yes, yes.
But my question is, can this particular document be taken into account by them in view of that procurement order?
This document has been taken into consideration by them, but it has been rejected on different considerations. Again, have a look at page 219. Annexure 13.
Yes.
Reference your letter number so and so, dated 12 September 2025. In this connection, it is intimated that as per Government of India Gazette notification number so and on verification of your MSME on Udyam registration portal, your certificate is showing as small enterprises. Then come, but as per the norms of MSME regulations, to be eligible for MSME renewal, your business must meet the following criteria. Then they refer to the criteria. Demand from me my information with respect to 24/25.
Mr. Pant, I hope you are not. I think you have not got my point.
Yes.
You see, in Assam we have the Assam Procurement Order Act,
Yes,
by
sir.
which all the procurement made in Assam is being followed.
Yes, sir.
As I could last check out, in the central government also has, you initially had in 2017 an order,
Yes.
a procurement order, and rules thereupon have been framed,
Yes, ma'am.
whereby certain historical documents are being allowed to take, which are already there on the portals.
Yes, ma'am.
So irrespective of all these things, if they can very well take into account that particular document in view of that provision,
Yes,
you are
Lord.
taken care of.
Yes,
You
yes.
see, the only problem which you are facing out here is that you have carelessly uploaded the medium certificate.
Yes, absolutely.
And because of you, this litigation.
That is right. That is right, Your Lordship. Now, my rejection is very important.
It's all the question of you being careless.
I was, Your Lordship, may kindly see, I was having two benefits with me. One was my enlistment as a contractor. Your Lordship, I have filed an additional affidavit before this honorable court. Your Lordship can go through that affidavit also. At that point of time, I was not MSME. I was only enlisted contractor. Bid security, EMD demand was more, but it was not taken from me because I was enlisted contractor. Enlisted contractors are otherwise also exempted if enlisted contractors.
You see, earlier they have already accepted this as a term, that it is required the twin condition.
Your Lordship, I think that Respondent 4 will clarify before Your Lordship that it was not twin conditions, are not required to be satisfied. They are independent of each other. And this is how it is being implemented throughout the country. My rejection is not I do not meet the twin conditions. My rejection is I do not meet any of the two conditions.
That case, Mr. Pant, you have not tried your luck to find out that aspect. You don't have a case. I'm trying to help you out, but
That
you are
your
not
lordship
helping
may grant
yourself.
me,
So
your
no
lordship may
point.
grant me some time. I'll think, my lord, in case I can do some research work on this, I'll come up.
Otherwise, you don't have a case. Because I have a big problem in not accepting what it is said, because otherwise it will go against 11B. Chalo.
Let's,
Yes.
firstly, Malas, my apologies for the little doctors which happened from my side. Malas, I just want to say in addition, there's another clause of NIT, clause 20. It specifically says clause 20 of the NIT. Malas, I'll just summarize it in 2 lines. Malas, this specifically says that whatever documents you're relying upon, has to be
Clause
uploaded.
20 of the NIT.
Please, my lord, see, serial page number 3.
Page number, clause 20.
It
Scan
says,
copy of the original instrument in respect of earnest money, integrity pack duly signed on each pages and under so and so, tender condition, enlisted firm. If firm is enlisted in bro, so and so, GST and other documents required.
and any other documents required to be submitted with request to various conditions mentioned in the tender documents.
All the record
Right.
documents should reach the tender inviting authority in No, madam, I duly take note of these. There's no
Right,
quarrel
please.
with that proposition.
Please,
The only thing is, I'm asking whether it is permissible as per the procurement order. That we need to look into it only. Otherwise you have a case. There's no
Right.
quarrel with that. Before you came, I was about to dismiss, and it is only your counsel out here who says that you are going to appear. That is why I'm not dismissing it today. I was about to dismiss, but he wanted only your presence to be recorded. So I have not dismissed it.
Please, madam. Madam, sir, it's just that we logged in at 2 o'clock. Sorry, madam, there was some misunderstanding. I thought it would be.
That I have understood,
Right,
but
right.
this is a thing which needs to be also looked into as to whether
Right.
there is a procurement order and
Right.
whether the rules permit this historical document to be taken note of. Because
Right.
this is otherwise available out there. If he has enclosed the MSME medium certificate at that point of time, it may obviously unless it is given in that certificate concerned that he is, because earlier, if I remember, those MSME certificates which used to be given prior to, which were not in that particular format, they used to give what is the investment. Now, after it has been tagged along as a Udyam and Aadhaar being tagged together, and thereby the amendment has happened in 8.2 of the MSME Act. So now they don't put how much is the investment. They put the thing out there categorically that this is what it is.
Right.
Now, what they have asked out here is that what they have asked at page 219 appears to be not correct, taking into account that this particular document categorically shows it to be a small. But the fact remains that this document was not there. So the only way by which I can permit them, the petitioner, is that if the petitioner produces some document, some order or something which is there in that particular procurement order or the rules framed therein under by the central government, that it is permissible to take that. Otherwise, the petitioner has no case.
Please, ma'am. Please, ma'am. I just thought of citing this clause because this also mandates that all these documents need to be uploaded at
No,
one
there's no
go,
quarrel
which
with
is a
that.
part
There's
of the
no
tender
quarrel. But
condition.
can these documents, because in there are many, like we have in Assam, there are some, because 2 days back I was reading into it. Let me give you the reference to that order. In fact, it is for the petitioner's counsel who should have brought it that aspect. But anyway, let me do it for his benefit. Provisions of Public Procurement Preference to Make in India Order 2017, something to that effect. These are all these there. So just find out as to whether any Public Procurement Act is there for the central government. If it is there, it will help you with the petitioner. You need not find out, madam. It is for the counsel for the
Well,
petitioner
it's
to find out.
only as an academic exercise.
Okay. Heard Mr. Arpon, the learned senior counsel, assisted by Mr. K. Kolte, appearing on behalf of the petitioner. Mr. H. Gupta appears on behalf of the respondent number 1 to 10 and Ms.
Tanupriya Gupta.
A. Sharma, na?
Miss Tanupriya Gupta.
Okay, so and so, who appears on behalf of the respondent number 11. This court have heard the learned counsels appearing on behalf of the parties at length. From the materials on record as well as the records produced by Mr. H. Gupta, the learned standing counsel appearing on behalf of the respondent number 1 to 10, it appears that the petitioner, though claimed the benefit in terms with clause 11 of the tender condition of the notice inviting tender as well as the tender condition, but the petitioner did not, though enlisted as a contractor, though validly enlisted as a contractor in the bro, with the bro, but enclosed the MOSME certificate were indeed showing that the petitioner is a medium enterprise. First, it is further seen that initially the respondent authorities have rejected the petitioner's bid inasmuch as the petitioner, though enlisted but did not, but the security so submitted was only to the tune of rupees 11 lakhs and not 15 lakhs. Be that as it may, subsequent to the representation submitted by the petitioner, the respondent authorities have further looked into the aspect as to whether the petitioner is an MSME and were of the opinion that the petitioner had submitted the document as a medium enterprise. The current case of the petitioner further is that the petitioner had become a small enterprise in view of the amendment made
Page 210.
made by the Ministry of Micro and Small Scale, made by the notification dated 21/3/2025 issued by the Ministry of Micro, Small and Medium Enterprise. And in that regard, the petitioner have also produced before this court a certificate which was printed out from the Udyam portal on 24/4/2025. Therefore, it's apparent that prior to submission of the bid of the petition, last date for submission of the bid, which is on 2nd of July 2000, on 16th of July 2025, the petitioner was admittedly an MSME small enterprise, was a small enterprise, and as such was entitled to the benefit in terms with section rule 170 bracket small Roman 1 of the GFR rules 2017. Be that as it may, the primary issue which arises is as to whether the petitioner, having not submitted the said document, which the petitioner was otherwise required to do so in terms with clause 20 of the notice inviting tender, the respondents were justified in rejecting the bid of the petitioner. Mr. R. Pant, the learned senior counsel, submits that he would request some time in this regard. Considering the above, list this matter again on 22nd of January 2026, 2 p.m. for an update for further hearing.
Obliged one.
Please, my lords.
My lords, I'm appearing virtually in item 28.
No, you're not here. Why should we take it?
My lords, I am.
We vacate your interim order.
My lords, may I please not do
You were
that.
supposed to come here.
My lords, I was supposed to come here, my lords. I apologize, my lords.
Fix this date. You're not here.
My lords, I have one request, my lords. 3 responses have been filed by the state L1 and L2. In response to this, my lords, I am seeking some accommodation to file a rejoinder and some additional documents, my lords, in response to whatever has come through.
Yes, you argue. We can't hear Mr. Rangan.
Lordship, as my colleague had already stated, 3 affidavits and oppositions have been filed, Your Lordship. 2 of them were filed Friday evening, Your Lordship, and we received the copies at around 3:15 PM, Your Lordship. Therefore, we need to file and reply to the same. And
You
we'll also
take 6
like to-
months to reply, no problem. We give you time.
My lords,
Have their mental satisfaction, let us vacate the interim order.
my lords may not do that, my lords. I am requesting my lords to list this matter immediately after the vacations, my lords. I will be
No,
present.
no,
for
no,
6
no.
days to finish the matter, my lords.
When you are enjoying an interim order,
No, my lords, the only reason I'm requesting for some time to file a rejoinder is because according to us,
affidavit to be filed or not before 12/12, they filed it on Friday.
my lords, I am seeking some time to file a consolidate one rejoinder to all 3 affidavits, mostly because a lot of statements made by the PWD in that affidavit directly contradicts their own documents on record. I want to bring certain things on record, including the fact that the PWD now is trying to improve their case in stark violation of the Constitution Bench judgment in MS Gill. Apart from that, all dates in terms of when the tender was admitted, when the tender was opened, is completely contrary to their own documents we have annexed. My lords, I am only it's important for us to put these documents on record so that our stand is on record. It's up.
You have not done it.
My lords, we wanted permission from my lords, we wanted your permission before we file a rejoinder. All I am seeking, my lords, is some short
Okay.
time.
Okay, we extend it subject to you submitting an indemnity bond as regards the expenses. Huh? We apply Ronak now.
I'm sorry, my lords.
We apply Ronak International and say that, okay, interim order stands continued subject to you depositing an indemnity bond stating that you are going to indemnify the loss to the PWD department in the circumstance you lose the case.
My lords, I have no instructions to sign that indemnity bond. I am humbly requesting my lords to just extend the interim order to one last date, and my lords may finish the writ petition on the next date. Once my lords has the advantage of the documents we want to file to show collusion between L1 and L2, and to also show how the PWD is now trying to improve its case. Something that the PWD cannot do. I can present these arguments orally, my lords, no problem on that. But tomorrow, if my lord's judgment is challenged by either party, subject to whatever my lord's
You are
holds.
referring to the Mohinder Singh Gill's judgment?
Yes, my lords. Yes, my lords. If I
But
can,
what do you say about Cybernet, Cybertech, Oasis Cybertech judgment?
My lords,
delivered on 24/11/2025 by the 3 judges bench.
I haven't seen the judgment, my lords. I will.
You are in Delhi.
Yes, my lords. I will take a look at the judgment. My lords, my point is very simple.
There in paragraph number 27, the Supreme Court said that if on contemporaneous material, it is not required to give a verbatim reason, exactly the verbatim reason out there. And what can be done is if they are having contemporaneous materials to suggest that these are the reasons for which it is to be rejected, that is it.
My lords, can I show 2 documents, my lords, to substantiate what I'm saying?
Okay.
At page.
So we decide on now itself.
My lords may give me some time to file a rejoinder because I just want to put my position on record, my lords. That's all, my lords. And I'm humbly requesting my lords to extend the interim order to the next date, at which point I will be personally present in court and we can finish this matter.
You gave an undertaking that thing last time.
My lords, I did, my lords.
Before, I remember on which date you said so.
It was, my lords, but unfortunately.
You said so on 12/11/2025.
I did, my lords, but
I have crossed 1 month till now. We don't see your face in the court.
My lords, I did. I apologize for that, but
that you want to do it by way of a virtual hearing. It is more expedient and much better for you.
No, my lords, I'm really sorry, my lords. I will be present on the next date, and I'm just requesting some time that we can file the rejoinder, place for the additional documents, and my lords may keep this on the day of reopening. My lords may finish this matter on that day, my lords, subject to my lords' convenience.
What? What do you say, Mr. Mohanto? For whom do you appear?
Number 3.
And you appear for respondent number 4. So both of you are very close. Why both of you are seen together in a photograph? That's the stand of the PWD. Huh? No, why have you taken the photograph together?
But that because it is in presence of the PW official, my lord. Because it's as per the rule.
No, no, that PWD official is not there. That was the submit. No, Mr. Mohanto, that was the very submission which was made on that day by Mr. B. Gogoi when the matter was taken up, that both the contractors are together in the photograph. Earlier, it was the submission of Mr. B. Chaudhary that, look here, one person has given the same certificate for both,
My lord.
same photograph for both. That was his submission. But the next time when the submission came from Mr. B. Gogoi, is look here, both of them are actually two different contractors. That is respond number 3 and respond number 4.
Ma'am,
And they happen to be very happily taking up together photographs to show that they have a site visit.
No, side visit.
ma'am, my lords, to add to this, they have now produced.
Presence of the, my lord, official of the PWD visit, my lord. Because
My lord,
No, why on earth you did not enclose that photograph with the PWD official
my lord.
as a site visit?
my lords, there is no such photograph. That is going to be clear from PWD's own counter affidavit.
Now it is clear that, my lord, I also, your lordship can see the record, my lord. I have annexed, my lord.
My lords, they have fabricated documents. My lords, please request me to file my rejoinder, and thereafter my lords may finally dispose this matter. It is my submission that two documents in the state's counter affidavit are fabricated, did not exist. They have manufactured documents after the writ petition was filed.
It is, my lord, mandatory condition. That is certified by the PW official, and that is my submitting in my tender paper, my lord. So that is that, from that what infer, my lord? Is it in any collision, my lord?
My lords, please take page 380 for a moment. The collusion will be rampantly clear.
In Guwahati. I'm asking question by the court and I'm giving reply.
I apologize.
So, my lord, that is the question, man. From that, my lord, it is not been answered till today, my lord. Even the affidavit which is filed by the, they have not even replied. It is filed on long back 5/12, my lord. 5/12. No reply has been filed to me.
So you want to give him a chance of filing a reply, which is he asking.
Why that stay
No.
will be continuing?
Huh?
Why the stay order? Because, my lord, your lordship kindly see the construction of a one
Circuit
circuit
house.
house. So, my lord, if it stays operating, my lord, probably price escalation is.
Circuit house where? Udalguri?
My lords, L1 and L2 have a history of doing contracts together. I'm going to produce at least 8 such contracts where they have bid together and they have won contracts together. This is not the only instance where these two bidders participate in bids together. My lords, may please give me one opportunity to bring those documents on record and respond to the state's counter affidavit to show that they have produced documents after the writ petition was filed. That's all, my lords. After that, my lords may decide whichever way. I'm obviously bound by my lord's decision. There are 2 documents in the state's counter affidavit which did not exist as on the date the writ petition was filed, and I will prove that, my lords.
No, with such serious allegations being there, wouldn't it be proper?
Lordship, if he makes that serious allegation, I will also have to counter if something new has new documents he brings on record. Lordship, in that way, it will carry on, and Lordship, ultimately the public interest. I'm saying that.
My lords, I am
Circuit house
only going to
for
bring on
everyone.
record public documents that they already have.
If he had the reason, besides the photograph, joint by photograph, Lordship, why he didn't bring it on record at the time of filing the writ petition? If it was still in an existence and with in his hand, Lordship.
My lords, these are all public documents. These are all public documents. They already have those documents in their possession.
He had enough time to bring that on record, and by today, Lordship, would have been prepared.
My lords, the only reason I did not file a rejoinder is because I would need your court's permission to file a rejoinder. The moment my lords permits, I will file my rejoinder, and my lords may have this on any date, my lords. That's all.
Okay. Mr. R. Chaudhary, appearing on behalf of the petitioner, submits that the respondent number 3 and 4 has filed their affidavit in opposition on 12/12/2025, and copies thereof have been served upon the counsel for the petitioner. She therefore submits that at least 7 days' time which is permitted as per the Guwahati High Court rules, be granted to the petitioner so that the petitioner is in a position to file the reply, taking into account the above, list this matter again on 7th of January 2026. The reply, if any, be filed on or before 5th of January 2026. Interim order passed earlier shall continue till the next date.
Lordship,
Most obliged, my lords.
Lordship, the courts will reopen on the 7th, Lordship. Fifth, Your Lordship. Therefore, having it on the 5th, may the date of submission take the letter on the 6th. Your Lordship. Date for filing the reply, Your Lordship.
Why?
Because the courts will be reopening on the 5th itself, so.
So, office is open. Give advance copies to them. You are entitled to file your reply by 19th. So ready, make it ready, or should I put it that you give a copy to them by 19th?
No, Your Lordship.
We will give a copy, my lords. We will give a copy.
What is my government and concerned, but they have not finally replied to you. It is long back it was filed.
You have not filed reply against the government affidavit also.
It was filed 5th.
Yes, my lords. Consciously, my lords, because there was no permission from this honorable court to file a rejoinder. My lords, rejoinder, as your lordships will appreciate, is a discretionary, is not a matter of right, my lords, which is why we did not file it unless and until we had the court's permission, which we do now. And we will file one reply, my lords, to all three counter affidavits.
Mr. Chaudhary, you need to go through our High Court rules properly.
I will, my lords.
Rejoinder is a right, additional affidavit is not a right.
I will, my lords. I will probably do.
So on that ground alone, my lord, extended the
Interim order may be extended.
I've extended.
Court orders item 15.
According to Lodhima Court order dated 27/10/2025, we have to make the paper publication upon respondent number 5.
Then, who is the respondent number 5?
Respondent number 5. Measures Assam Yarn Supplier.
What? What is your case?
Closure. Non-payment of terminal benefit. Terminal benefit to the employee.
Who is to pay? Who is to pay that amount?
Some
Why do you need that respondent number 5? Who is paying for the government?
May I kindly close the order at 27/4/23, Lordship.
27?
4/23, Lordship.
Who has transferred this to the Assam Yarn? Is this firm in existence?
That instruction I have not. Lordship.
Find it out. Because why it is required means the problem is why the service has not been. You see, they have their office out here.
Lordship. No, their
If
office,
this industrial undertaking has been transferred,
their office probably shifted to Mumbai, Lordship.
but is that establishment here or not?
That part I.
No, this is what was the submission. The basic
Yes.
prayer made in the writ petition pertains to the claim of the payment of retrenchment compensation. According to Mr. Dasgupta, the state of Assam would be liable to make the payment. Whereas Mr. Kolita submits that the ownership of the industrial unit has been transferred to Assam Yarn Supplier Registered Partnership Firm and so, and therefore the same is required. So this is what has been mentioned. So if it is being transferred by the state government and it is an undertaking which is in Assam, so you must be knowing it. Here we are concerned with these poor workmen who were there. Asking now for them to make a paper publication in a newspaper in Bombay would be too much for them. One has to understand that. We will do so in respect to any other contractual matter, we will do so. But not in a case of this type. Yes, finance, you'll be knowing it, you have taken the money. Are you in a position to carry out the paper publication? We do one thing, wait. Mr. Gogoi, you just find out whether this establishment is still functioning, where they were retrenched from. It is seen from the records that the establishment wherein the petitioners were working earlier has been transferred by the state of Assam to the respondent number 5. Under such circumstances, Mr. B. Gogoi, who appears on behalf of the Industries Department of the Government of Assam, shall apprise this court on the next date as to whether the said establishment is still functioning within the state of Assam. Huh? Gogoi. Okay. Let's this matter again on. You find it out on 9th of 11th of February. 11th of February. কাগজখন ক'ত গ'ল? কাগজখন গ'ল নেকি কাগজখন? What is this?
The infectious law.
Lozima observed the notice issued through usual process has been duly served, hence service upon is complete. Okay, taking into account the order of the Lozima court, the service being complete, lists the matter for admission on urgency, no urgency.
Otherwise infectious law.
Huh?
Otherwise infectious law.
Okay, let's dismiss
Lot.
it.
Lot.
What is this?
It was,
Infructuous.
License was given inside the jurisdiction of Amargaon Panchayat, and the shop has been shifted to Lukhipur municipal area. So the objection of the public nearby the shop were not to establish the shop within that Panchayat, and that has already been shifted to Lukhipur.
Now what do you want?
So the objection.
Have you shifted?
Yes, shifted. Shifted.
The learned counsel appearing on behalf of the petitioner submits that in view of the permission being granted to the petitioner to shift. Have you shifted or not?
Shifted, that has been shifted.
Shift. And the petitioner having already shifted, nothing further.
I was against.
Respondent number has shifted lot. Respondent number
6 has shifted that shop.
You are against
Establishment of that shop.
in the Gaon Panchayat.
In the government side.
Now he has shifted.
Yes, shifted lot.
The learned counsel appearing on behalf of the petitioner submits that the petitioner's grievance in the instant proceedings related to the setting up of the IMFL wine shop off.
Initially it was on, subsequently it was converted to off lot.
IMFL or wine shop by the respondent number 6 within the Dhamar Gaon Panchayat.
Yes.
However, during the pendency of the instant proceedings, the respondent number 6 has shifted to the
Shop to the ward number 9, Lakhipur Municipal.
Lakhimpur
Lakhipur. Municipal Board.
to ward number 9, Lakhipur Municipal Board. Within the jurisdiction of the Lakhipur Municipal Board. So taking into account the above, no further, no cause of action further survives in the instant proceedings. Accordingly, the writ petition stands closed. Mr. Talukdar, you appear for somebody?
Six.
Okay.
I'm for 1 to 5. 1 to 5.
What is this? Wakalatnama filed on behalf of 6. Then,
Here on behalf of 3 and 5. And remaining already
what is the matter about?
It's a tender matter, my lord. The petitioner hearing, my lord, is agreed by rejection of this tender on rejection of his technical bid on the ground that he had not submitted a document which was exempted, my lord. The petitioner is an MSc.
What remains?
My lord, the-
Nothing remains, my lord. Everybody has got.
Instructions.
It survives, my lord.
What? You have been already there. The technical bid that your interim order was passed, it has been vacated.
Vacated, but it was made subject to outcome.
No outcome.
Smith is
The empanelment of the petitioner will be subject to outcome.
Similar petitions have already been decided recently, my lord, and 2 petitioners have got impaneled recently, my lord, in terms of this court order, my lord.
Not recently, it is.
Recently.
Empanel where?
Empaneled in the handloom and textile department. When lordship comes to the tender, my lord.
No.
Page, it starts from page.
That was
51.
8 months back, my lord.
Huh?
4th February 25, my lord.
Huh.
And it was for 1 year, my lord.
Oh, it has
They
been
do-
extended, my lord.
I don't have
Extended.
I don't have that instruction, my lord.
Empanelment is for a particular period. Empanelment
The
is for a purpose of formation of a rate contract.
Yeah.
Well, this is nothing there.
My lord, similarly situated persons have been granted the benefit, my lord.
Who has granted you?
But this honorable court, my lord, I can give the order.
Which court?
Court number, Honorable Justice, Mr. Honorable Justice.
Michael.
Oh. Then we place it before him.
One review is pending, my lord. He
Review
has
is
filed
pe-
one review. There are altogether, my lord,
He's trying to complicate.
my lord, there were total 5
You-
writ petitions.
Oh, Mr. Sharma, you have to understand, Mr. Ardhor is expert in that. To complicate.
My lord,
Very big.
there were 5 writ petitions, my lord.
Hmm.
4 disposed, my lord.
Yeah.
There was a direction, my lord, from this court to go ahead with the, my lord, empanelment, supply order, everything we did. One, he is aggrieved, my lord, he has filed a review that is still pending before the
Okay,
particular court.
let us have it after vacation. Taking into account that the service is duly complete, list this matter again on 28/1/2026 for admission.
In the meantime, my lord, they may file their affair case. my lord.
You're not filing.
So
I-
this
I
file,
have-
The private respondents.
Recently, I have appeared, but the in the main repetition, there is no allegation against me.
You don't want to file.
But my lord, when I gone through the record, the affidavit has been replied by the department against which reason has been filed by the petitioner. There are some materials are there.
There's no prayer
So
against
may I
this.
pray for the supplying the extra copy of the reason? If there is anything, I will file.
Mr. Nath, I don't go by all these submissions here. If you have anything, both of you are, I think you know, are you in talking terms?
Problem.
18.
Not so.
Yes, review petition. Where is this? Oh, this one, another one.
It's around 2nd of February, review petition number 279.
Okay, list this matter on 2nd of February along with review petition number 279/2025. On one day, we'll take up all.
Yes.
I could have finished up that matter today. Not one chance. But I think the central government has the procurement rules. In fact, should have been his submission. Sad.